Order. Appreciate everybody being here, and I appreciate everybody being respectful of everybody else. Thank you very much. The very first bill is Senator. Yep, I'm sorry. Please call the roll.
A quorum is present, Mr. Chairman.
Okay. The first bill is Delegate Levine's bill. It's House Bill 961, having to do with assault weapons. Okay, Delegate Levine.
Thank you, Mr. Chairman.
By the way, we're going to give 5 minutes each side, okay? 5 minutes for the pro side, 5 minutes for the anti side, for the whole group. So speak very quickly, okay? Delegate Levine.
I don't know if that comes out of my time or not, but
No, it doesn't come out of your time.
Okay, I'll try to be brief, though. Thank you, Mr. Chairman, members of the committee. HB 961 is a bill to regulate assault weapons. These weapons have been regulated in 9 states and D.C. There was a federal assault weapons ban. It also would ban trigger activators, otherwise known as bump stocks, and large capacity magazines. Assault weapons and large capacity magazines have been used in virtually every recent mass murder. They were used in 5 out of 6 of the mass murders of the last 40 years. These weapons were used at Aurora, at Columbine, at Orlando, in Pittsburgh, in Virginia Tech, and Virginia Beach. These weapons pose a real danger. The moment when a mass killer has to change a magazine is a moment of weakness. In Gabby Gifford's case, she is alive today because a brave woman by the name of Patricia Maish got the killer's magazine as he was changing it. There are people in Nashville, Tennessee that are alive today because at the Waffle House, a man by the name of James Earl rushed the gunman as he was changing magazines, grabbed the red hot barrel of the gun, and wrestled it away from him, and that's why people are alive. These weapons are not necessary for hunting. They're not necessary for self-defense. And for target shooting, it's pretty easy to get another magazine fitted. Now, this bill has gone through a number of changes.
Mr. Chairman.
Yes, Senator Stewart.
I'm having a hard time with this. I just wonder if the gentleman might explain to me what he's calling an assault weapon.
Absolutely. The assault weapon comes largely from the federal assault weapons ban. And it is a weapon with either, depends whether you're talking about a rifle, a pistol, a shotgun. They're all defined in the bill. For a rifle, it would be one with either a fixed magazine of greater than 12 bullets capacity or a detachable magazine and one of several features in the bill.
So, Mr. Chairman.
Senator Stewart.
So if I have a bolt action rifle that's capable of receiving a clip or a magazine with a certain amount of shells, does that fall within your definition of an assault weapon?
It does not. It has to be a semi-automatic center-fired weapon.
And that's found where?
It's found in the definition. You can find it in section 12.23089, lines 396, 398, a semi-automatic center-fired rifle that expels single or multiple projectiles by action of explosion of combustible material, that has the ability to attach a detachable magazine, and has one of the following characteristics: a folding or telescoping stock, a pistol grip that protrudes conspicuously beneath the action of the rifle, a second hand grip or protruding grip, a grenade launcher, a flare launcher, a silencer, a flash suppressor, a muzzle brake, a muzzle compensator, or a threaded barrel capable of accepting one of them. Is this?
Thank you.
That's for a rifle. For a shotgun, you can't have more than 7 bullets. You can't have a revolving cylinder, and the pistol is in here as well.
Okay, go ahead. Yes, Senator Norman.
Thank you, Mr. Chairman. While we've interrupted you, I want to ask you a very parochial question. And on the version I'm looking at over on page 8 of 9, on line 470, it talks about the provisions shall not be applicable. And my question to you is it your intention that this entire bill would be applicable to the Corps of Cadets at VMI and Virginia Tech as it relates to licensed firearm training?
No, sir. The military is exempted. The law enforcement is exempted. And of course, in this bill, no one has to give up their gun anywhere in Virginia. People can keep their guns. It bans future sale and possession. But law enforcement and
Okay.
the military are
Mr. Chairman,
expressly
I read it.
exempted.
I just
Yeah,
want to
that's Senator
be
Norman.
clear on your intent that it would not be applicable to those situations.
That's correct, and manufacturers for those.
All right,
There's
thank
also transfers allowed, for example, transfers while hunting, transfers at target shooting, family transfers, et cetera.
Okay, go ahead, Delegate Levine.
Mr. Chairman.
Yeah, Senator Obenshain.
So this requires, if you own a magazine that exceeds the capacity, it requires you to surrender it?
It would ask you to get a new magazine. You have a year to do that.
What does it require you to do with the old magazine?
You can sell it within that year. You can transfer it to someone who's allowed to have it. You can,
So you can sell it?
in that year, yes.
You
It doesn't go into
anticipate-
effect until January 1st, 2021.
So, all right, how about the person who buys it? What are they supposed to do with it?
Well, if they're out of state and they can legally have it, then everything's
If they sell it
fine.
in-state?
They cannot after January 1st, 2021.
What are they supposed to then do with it?
They can discard it. They can render it inoperable.
Throw it in the trash?
They can do that. They can turn it over to the police.
Do you
They-
have any provision in this bill for compensating people for
Actually-
taking their property?
Yes, Mr. Chairman,
Yeah,
Mr.
Delegate
Obenshain.
Levine, go ahead.
Buybacks are allowed in this bill, and
Provided for or allowed?
they are allowed if folks, and I actually think there'll be a number of folks who might
Is
want to
there-
give money for
Mr.
such a
Chairman, is there
buyback.
money in the
Senator
budget,
Overshain.
in the House budget for buybacks?
I don't believe there's money in the House budget. However, I would certainly welcome that.
Right, Mr. Chairman,
Senator Obenshain.
so have you been in a gun shop recently?
Not recently.
All right.
I have been in a gun shop.
Mr. Chair, well,
Yeah,
that's
Senator
good.
Overshain.
That's good. Mr. Chairman, what I would ask is, do you know how many of the how many full-size semi-automatic handguns even have magazines manufactured for them that have 12 or fewer rounds in capacity?
Mr. Chairman, I would say the gentleman, there are quite a few. In fact, one of the reasons we chose
Full size.
12 rather than 10 was because the Sig Sauer is a commonly used weapon that has a 12-bullet magazine. So we do know that there are.
So all Sig Sauer semi-automatic handguns have 12-round magazines?
Mr. Chairman, I didn't say all did, but a very common version does, including the ones used by police until just 2 years ago. Now, I understand that they have 13 bullets, but of course, there's an exception here for law enforcement with their
Do you know
service
what the
weapon.
Senator Overshain.
P229 has? How many rounds that magazine accepts?
Mr. Chairman, I can't speak to the specifics of each and every Sig Sauer. I know that 12 bullets is a common.
Okay.
All right.
All right, thank you.
Yeah, go ahead. Continue.
Chairman?
Continue, yeah, Senator
Chairman,
Short.
I'm sorry, I just want to make sure I understand it, Bill. Delegate, I've been reading your definition and thinking about this thing. Correct me if I'm wrong. Would your bill make virtually every semi-automatic rifle and every semi-automatic pistol in Virginia an assault weapon?
Mr. Chairman, absolutely not. It is the weapons that have these features that make them more useful for mass killing.
Mr. Chairman?
Yeah, Senator Stewart.
But don't virtually every semi-automatic rifle and every semi-automatic pistol have the capability of inserting a clip into it? And if that clip is capable of holding more than 12 rounds, then it's, under your definition, it's a semi-automatic, an assault weapon.
Mr. Chairman, I would say, first of all, we should all remember that this weapon lets everyone who has a gun keep their gun. So we're only talking about future purchases and sales. With regard to future purchases and sales, it must have a detachable magazine and one of these features, like a grenade launcher or flare launcher or a flash suppressor or some of these military-type
Chairman.
features that were used.
Senator Stewart.
If it's a semi-automatic weapon and it's capable of receiving a clip or magazine, whatever you want to call it, that could hold more than 12 rounds, under your definition, isn't an assault weapon.
Mr. Chairman, that's not correct.
That's not correct?
That's not correct.
Can
It
you
must,
correct me?
Sure.
Explain to me where I'm wrong?
because it must have one of these military-style features. like the ones featured in the federal assault weapons ban that was so successful in keeping down mass murders. Yes, it has to be semi-automatic. Yes, it has to be center fired. Yes, it has to have a detachable magazine unless it has a fixed magazine of more than 12. But it must also have one of the features that you'll find in lines 400 to 404 of the bill.
Okay?
Thank you, Mr.
Okay,
Chairman.
go ahead. Continue.
I would just simply say that this weapons restriction is clearly constitutional. Every single court in the nation, every federal appellate court in the nation that has looked at this issue has ruled it. DC Circuit, First Circuit, Second Circuit, Third Circuit, Fourth Circuit's most important to us because it includes Virginia. In the Colby v. Hogan case, they looked at Maryland's law, which is far more restrictive than this bill, actually bans the weapons, bans possession of the weapons. And the court found that assault weapons are, quote, weapons of war, unquote, not my words, the words of the Colby court. And therefore, as weapons of war, under Heller, they are not protected under the Second Amendment. The case was appealed to the United States Supreme Court. The United States Supreme Court denied certiorari. They declined to review it. That wasn't the first time they declined to review such a case. They've done so in other cases, and there are other circuits than just the ones I've mentioned. The point is, there's not a single appellate court in the nation that has said that these are unconstitutional. So I understand that some people may disagree with the policy here, but there should be no question as to the constitutionality of this bill.
Okay, anything else?
I think that's about it,
Okay,
except
all
to say that this bill will save lives. We have seen the federal assault weapons ban. We saw the incidence of fatalities of mass murders go down 70% during that 10-year period, and then they've shot up again. This bill will save lives just like it saved Gabby Gifford's life. And again, any gun you have, you can get a magazine that's fitted with less than a 12-bullet magazine. That's what they do in California. That's what they do in New York and Maryland and other states. So it really doesn't affect someone using these guns for hunting, for target shooting, for self-defense. It would, however, save lives from mass murder. Thank
Okay,
you.
Thank you very
Mr.
much.
Chairman, members
Now,
of the
for the
committee.
pro side, those that support the bill, line up. You'll have 5 minutes each. 5 minutes for
I
the
didn't
group.
prepare- I didn't prepare
For
5
each
minutes.
side, 5 minutes for everybody on the pro side, and then 5 minutes for everybody on the anti side.
Mr. Chairman, members of the committee, Brian Moran, Secretary of Public Safety and Homeland Security, thank you very much. I think Delegate Levine has indeed described the bill well. This bill has been described in a number of other ways. It does not amount to a gun grab. It is not registration. It is not unconstitutional. It does not make our fellow Virginians felons overnight. It does not address possession of these firearms at all. Now, it does address possession of magazines over 12 rounds, but we provide additional time for their disposal and punishes it as a misdemeanor, not a felony. So, I appreciate, that I know this has been mischaracterized in any number of ways, but those are the salient features of this legislation. We have listened to the opposition at each and every one of these hearings and throughout the course of the special session in July and from the special session to January. So that is why this bill accommodates many of the opponents' objections. And so no longer registration, and only deals with the possession of over 12 rounds. We bumped it from 10 to 12. So this really is a far different substitute than you've seen previously last year or in the special session. Now, with respect to the constitutionality, I know we have a lot of constitutional scholars, but I would address in Colby versus Hogan, which was decided in 2017, Heller being decided in 2008, in Colby, and I quote, "We conclude that the banned assault weapons and large capacity magazines are not protected by the Second Amendment. That is, we are convinced that the banned assault weapons and large capacity magazines are among those arms that are like M16 rifles, weapons that are most useful in military service, which the Heller Court singled out as being beyond the Second Amendment's reach. We have no power to extend the Second Amendment protection to weapons of war."
Okay.
Their words, not mine. So
3 minutes
constitutionally,
left.
it has been challenged, and as you well know, and this
Chairman.
committee knows that if this law were to be challenged, it would go to the First Circuit, which is exactly the same court that ruled
Mr. Chairman,
and the Maryland law was far more restrictive than this bill that you're
Chairman.
considering.
Senator Stewart.
Thank you, Mr. Chairman. Secretary Moran, my recollection is that you were a good lawyer.
I appreciate that.
Before you became this very astute lawyer, and I want you to tell me on line 406. He was a good lawyer. Line 406, paragraph 3 says, a semi-automatic centerfire pistol that expels single or multiple projectiles by action of a explosion of a combustible material with a fixed magazine capacity in excess of 12 rounds. What does that mean?
That's the fixed magazine.
What does that mean?
They're very uncommon, but that's where it's not
Mr. Chairman, when you insert a clip or a magazine into that, is it not fixed?
Yeah, no, it's not fixed. You would purchase the pistol with the magazine attached. It's fixed, is what I understand.
How do you put
So it's only the detachable magazine that you had questions with respect to whether or not the capability previously to Delegate Levine. And it is indeed a three-part test because on line 399, it used the conjunctive and. So it's a detachable magazine with the capability, semi-automatic, and one of the following characteristics that you see through 400 to 405. With respect to the fixed magazines, they're very uncommon, what I understand, having a fixed magazine.
But once you insert the magazine into it, isn't it then fixed into the weapon?
No, because I think then it's detachable. I mean, you can take it out.
Thank you, Mr. Chairman.
Okay?
Yeah.
You got.
Thank you very much,
listen,
Mr. Chairman.
okay. Next.
Hi, good morning. My name is Kyle Ann Hunter, Vice President of Programs for Brady. As a combat veteran and proud gun owner, I rise in support of this bill. In Iraq and Afghanistan, I saw the uniquely deadly characteristics of firearms such as these. And as a Marine, I fought to secure the blessings of liberty here in this country. Time and time again, we have seen these weapons cause fear, cause destruction, and cause mass murder. And there is no place for them in our streets today.
Okay, thank you. All right, next, you got 2 minutes and 10 seconds.
Good morning, Senator Edwards. My name is Peter Reed, current constituent of Senator Peterson, former constituent of Senator Sasslaw. I find nothing funny or amusing about this conversation, and I would ask the committee to keep that in mind. Senator Sasslaw was my senator on April 16, 2007, when my daughter Mary and 31 others were shot to death on the campus of Virginia Tech in Blacksburg. I am coming to you also as a combat veteran of the United States Air Force who has fired everything up to and including the M60 machine gun and light anti-tank weapon. I don't need any instruction on assault weapons, and I don't need to listen to a definitional debate. I am here to talk about a life and death issue. I do not want to see any other families or victims of mass shootings have to endure them at the hands of an assailant armed with weapons covered by this bill. The Secretary, Kaya, Delegate Levine have made the case for the common sense of this. They have made the case for the constitutionality of this particular bill. Senator Peterson, this bill does not infringe anyone's rights. It is a matter of life and death for these families and these victims. I beg you, I implore you, as I have for over a decade, pass this bill.
Okay, thank you. All right, got 53 seconds.
My name is Basma Madawi. I'm co-founder of March for Lives Virginia Beach, and I'm in support of this bill. In Virginia Beach, 12 people were killed in Municipal Building 2, and the gunman used a high-capacity magazine. This bill would have effectively banned that magazine. All I'm asking for is for peace, for me and for my peers and for all the young people in Virginia. My city remains on edge. I'm tired of my classmates flinching at the sound of a loud sound in the hallway, fearing they will become a statistic. I'm tired of fear. I'm tired of violence. I'm tired of inaction. Now is the time for change, and this bill is that change.
Thank you very much. All right, next. 20 seconds.
Good morning. My name is Lori House. I'm with the Coalition to Stop Gun Violence, and my daughter was shot and injured at Virginia Tech on April 16th, 2007.
Go ahead.
What else can we say to you? People are dying, and you care more about a piece of hardware.
Okay, thank you. Okay, go ahead. I'll just continue.
Chairman,
I'll
Andrew
give
Goddard.
30 more seconds.
Andrew Goddard, Virginia Centre for Public Safety. We support this bill as it was originally drafted, which would have been a much better bill. Thank you.
I'm going to extend everybody, how many people are still there? Raise your hand. All right, I'll add 2 more minutes. It'll be 7 minutes for both sides.
Josh Horowitz, Educational Fund to Stop Gun Violence. We support this bill. I would say people say, why 12 rounds? If you were shot with the 13th, 14th, 15th, 16th, 17th, or 18th round, you'd know why this matters. This will save lives. The evidence shows that. Please support this bill.
Okay, thank you. Next.
Joanne Sweeney. I'm a citizen of Chesterfield County. I also represent the Liberal Women of Chesterfield County, and we support this bill.
Okay. Next.
Brittany Whitley with the Office of the Attorney General, and on behalf of Attorney General Mark Herring, we do support the bill.
Okay, thank you. All right, one more minute. Is anybody on the pro side? Okay, thank you very much. Now, on the anti side, we'll give 6 minutes, since they took 6.
Thank you, Senator. We're just a
Okay.
strange circumstance here. Good to see you all today. You sit on this
Welcome,
committee.
Congressman. Welcome.
Thank you. I represent Showmasters and Red, White, and Blue Enterprises, but I'm also representing myself and my opinions, but more importantly, legal precedent. Secretary Moran discussed Colby versus Hogan. I invite members of the committee to Google search Colby versus Hogan, when the first story that comes up will be Colby versus Hogan defies Supreme Court. And I will tell you that I'm sort of conflicted here because, candidly, I have a personal interest in this, but beyond that, I feel like it's my duty to tell you that if you pass this legislation, there are better lawyers than myself and people in this room, no offense, who are clamoring for the opportunity not only to overrule this draconian piece of gun legislation, but all of the gun legislation across the country. I want you to consider not only the ruling in Heller, but also the rulings in Heller 2 and Heller 3 and the rulings out of the Southern District of California in 2019 under Judge Benitez that would strike down parts of this bill as unconstitutional. So now we're looking at the D.C. Court of Appeals and the Southern District of California, not traditionally conservative pro-Second Amendment jurisdictions, and a trend in precedents against this bill. Now, not only did a good point get brought out as it relates to the money for buybacks on magazines, but the legislative cost, the litigatory cost of this legislation will be beyond what you can comprehend. And I promise you it's in neither chamber's budget. So with that in mind, above and beyond the constitutional reasons, this thing will get struck down and it will do exactly the opposite of what you intend. It will create a circumstance wherein all gun bans that defy the Second Amendment and Heller in common use are overruled for perpetuity. And with that, I thank you.
Yeah, thank you, Congressman Tom Garrett, former state senator. Thanks for being here. Okay.
Philip Van Cleve, Virginia Citizens Defense League. There's so much wrong with this bill, it's hard to even begin on it, but we'll hit a few things. Number one, the whole constitutionality has never been tested in Virginia. We have a very powerful protection for gun rights, Article 1, Section 13, that makes it clear that everybody is a member of the unorganized militia, as well as you're expected to be trained to arms. So this challenge, as far as I'm concerned, would begin in Virginia, a whole different area. Number two, speaking about mag size, the Virginia Tech Commission, right after the shooting, in their report, stated in there that magazine size would have made no difference to the outcome. That the 10-round magazines, if that's what Cho had used, would have not have changed anything. By the way, violent crime was dropping during the time of the assault weapon ban. It continued to drop after the ban expired. Virginia is 4th from the bottom for a violent crime rate in the United States. We're doing a good job. Thank you.
Thank you.
Chairman,
Next.
Mr. Chairman.
Yeah, Senator
Question of
Morrissey.
Mr. Van Cleve.
Yeah, Senator Morrissey, here's a question.
Thank you, Mr. Chairman. Mr. Van Cleve, Secretary Moran mentioned the 2017 United States Supreme Court decision that, of course, does apply to Virginia and the other 49 states. How do you ascertain that decision with your statement that the constitutionality has not been tested in Virginia?
Well, it wasn't the Supreme Court in 2017, I don't believe. I believe that was the Circuit Court.
Did you hear Secretary Moran mention the U.S. Supreme Court decision in 2017 that opined on the constitutionality of the ban on, I'll move on to another question. What is the difference between this legislation by Delegate Levine and the federal assault ban legislation that the Supreme Court has ruled is constitutional?
Big differences. Number one, the ban that Delegate Levine has only requires one feature to ban a gun. It bans a whole host more guns. The federal law allowed you to have two features. For example, you could have a pistol grip and the removable magazine, or you could have a flash suppressor and so forth. So you can't have If you have one of those things, the gun's struck down. So it's significantly stiffer.
All right, final question, Mr.
Yeah,
Chairman.
Senator Morrissey.
The Colby decision in 2017, which was a Fourth Circuit decision, didn't go up to the Supreme Court. It was a Fourth Circuit Court decision that said that the legislation was past constitutional muster. Do you agree that that Fourth Circuit decision is applicable to Virginia?
I think we have our own Supreme Court with our own laws to look at. We have to look at our own Constitution as well.
Thank you very much.
Okay, thank you. All right, next, I had 2 more minutes, but I'm going to make it 3 more minutes because the other side got 6 minutes.
Good morning, Mr. Chairman, members of the committee. My name is DJ Spiker with the National Rifle Association. We oppose this bill for another reason stated previously. One thing to note here, for our border counties and those individuals who are wishing to hunt from out of state, you cannot bring your firearm with you. If you do and bring it back into Virginia, you are now a felon. If you go across the Bay Bridge in order to hunt on the Eastern Shore and transport your weapon and bring it back in, it is a Class 6 felony per the definition of this bill. There are a lot of concerns with this bill. It is unfortunately turned into a Frankenstein, but this time we'll absolutely oppose this bill. Thank you.
Next.
Thank you, Mr. Chairman. My name is David Adams. I represent the Virginia Shooting Sports Association, the state affiliate of the NRA. We have thousands of individual gun owners across the Commonwealth, as well as 26 affiliated shooting ranges across the Commonwealth, including one in your backyard, Mr. Chairman, the Roanoke Rifle and Revolver Club. There are an estimated 10,000 competitive shooters in Virginia. Many of those are members of our association. Folks who come in and compete at our ranges throughout March through September come in from out of state as well. They would no longer be able to come in and participate in rifle competitions. The patron has said that we get to keep our firearms. That doesn't help you if you're coming in from out of state and you're transporting the firearm, which is something this bill does. I urge you to defeat the bill. Thank you, sir.
Okay, next, thank you.
John Quapis, Chesterfield County. This bill is fraudulent in its claims and fraudulent in its claimed effects. Number one, the Department of Defense and NATO has defined as an assault weapon as one capable of automatic fire. None of these weapons are capable of automatic fire. They are semi-automatic. These weapons are bought primarily as self-defense weapons, home defense weapons. That's a major interest of people in having these weapons. They're becoming very popular for that. You can get a DVD telling you all about how to do it. This is not a weapon that's seriously a problem in Virginia. There have been no so-called assault weapons used in any mass murder killings in this state. Of the 117 documented killings, mass killings from 1982 to 2019, of those 117, only 25% used assault weapons, quote unquote. The rest were handguns. There was a study done by Boston University on 25 years of federal data on this. It found, let me quote you, laws regulating the types of weapons people have access to, such as assault weapons bans and large capacity ammunition magazine bans, have no effect on the rate of firearms-related homicides. This is not going to reduce mass killings. It's not going to reduce murders. It can actually increase them because it gives a disadvantage to the criminal and the mentally ill person. The self-defending homeowner, et cetera, is disadvantaged. They are partially disarmed because they can't use these weapons because the magazines are smaller. A mother trying to defend her children at home, she has to constantly change magazines at 12 a magazine. She can get shot and killed during that as opposed to having a 20 or 30 round magazine. This bill is actually horrendous. It does no good. It will actually harm the state.
Okay, thank you. Next.
Good morning, Mr. Chairman, members of the committee. Trevor Santos with the National Shooting Sports Foundation, the Trade Association for America's Firearms Industry. We oppose this legislation. Not only do we have issues with banning future possession and sale of commonly owned firearms, there's a provision that allows manufacture for sale to law enforcement and military. However, there are issues with distributors and retailers who currently have contracts with Department of Defense, law enforcement, as well as U.S. contractors. For those reasons, we oppose this bill. Thank you.
All right. Come up, your time is probably, come up and say who you are and very quickly.
Mr. Chairman, thank you. My name is Knox Williams with the American Suppressor Association. For many reasons, we oppose this bill. Chief among them is the fact that a suppressor is a tool that does help protect thousands of people's hearing within this state, whether they're hunters or recreational target shooters. According to peer-reviewed research, the most serious threat to hearing comes from recreational hunting or target shooting. And that's why the National Hearing Conservation Association supports the use of firearm suppressors to help mitigate preventable hearing damage.
Okay, thank you.
Thank you, sir.
Senator, just state your name and your position.
Patricia Webb, I am a licensed FFL. This bill, if passed as written, would put over 2,000 licensed firearms dealers in this state out of business because it would essentially ban the vast majority of items that we sell. Most of the features that are listed as, quote, assault features are actually safety features. And a lot of them are designed to help people with disabilities to be able to better control the firearm. So I respectfully ask that you kill this bill. Thank you.
I'm ready to this. Okay.
Scott Jenkins, Culpeper Sheriff, strongly against the bill.
Okay.
We owe it to our constituents. If you vote in favor of this
Mr.
bill,
Chair.
you should explain why and what good it will do.
Mr. Chair, we've gone way over
I
time.
know we have. We have a lot of people here. Step up and say who you are.
I've got a motion.
Okay, just a minute. Go ahead.
Grayson County Sheriff Richard Vaughn, I do oppose the bill. It's a bad bill. Thank you.
Very quickly, very quickly. Just want everybody to state their name and.
Hey,
their
Mark
position.
Curtis from Beaver Dam, Virginia. We're trying to make sure that this bill's
Okay,
done
thank
make
you.
it there.
How many people are back there that would like to say something? Raise your hand. All right, very quickly. We're not going to let everybody, but come on up. You've gone over time, but go ahead.
I understand. Candy Eubank, I'm a wife, a mother, and a woman, and I need this bill. I oppose this bill because I need to protect myself.
Okay,
Thank you.
thank you. Does everybody back there agree with what everybody has said? Go ahead, very quickly. Go ahead, very quickly.
Pat Grandelli, my daughter Katie interned for Senator Boysko last year. I oppose this bill, and the grandfather clause will certainly violate the 14th Amendment.
Okay, thank you. All right, this will be the last person.
My name is Arsalan. I want to speak to everyone that says the Supreme Court has approved this case. They're holding a case out of Massachusetts, Warman v. Healy, that challenges the AR-15 ban out of Massachusetts. The Colby v. Hogan case didn't stop importing of 30-round magazines.
Okay.
The resolution pending in the New York State Rifle Pistol Association, whatever standard of review that they put in there, that will make these kind of laws constitutional, not constitutional.
Okay, thank you. Thank you very much. Would the patron like to say one last word and wrap it up?
Well, and I promise I will be very brief.
Okay.
There is an exception for manufacturers for the military, so that's right there in the bill. Suppressors are allowed under the legislation. If you like your suppressor, you can keep your suppressor. For those that complain about Article 1, Section 13 of the Virginia Constitution, the Virginia Supreme Court held in 2011 in the D. Giacinto v. Rector and Visitors of George Mason University case, 704 Southeast 2nd, 365, that the Virginia Bill of Rights protections are coextensive with the Second Amendment. The Colby case was appealed to the United States Supreme Court. The United States Supreme Court declined to hear it, cert denied in 2017, 138 Supreme Court, 469. And lastly, if you're using these guns for self-defense in your home, I guess you'll only be in trouble if 13 people come to burglarize your home in the middle of the night. I think that's quite unlikely. People can use shotguns to shoot several pellets out at once. These guns are not made for home defense. They're made for mass murder. Thank you for your time.
That completes the public
Mr.
hearing.
Chair.
Yeah, Senator Deeds.
Mr. Chair, we passed a lot of gun bills this year. There are obviously a lot of questions about definitions in this bill, and definitions do matter. I would move that you carry this bill over till the 2021 session and write a letter to the Crime Commission, ask them to take a look at the definitions contained in this bill.
Mr. Chairman. It's been moved and seconded the bill be carried over.
Mr. Chairman,
Substitute motion,
Mr.
Chairman.
Just a
Substitute
minute,
motion,
just a
Mr. Chairman.
minute, just a minute. Senator Morrissey.
Thank you, Mr. Chairman. A substitute motion to pass it by for the day and not the year.
Second. Mr. Chairman.
It's been moved and seconded to pass it by for the day and not the year. Senator Short.
Mr. Chairman, I make a motion to pass the bill by indefinitely. Well,
we got three motions. All right, we have the first motion is to pass it by for the day.
Mr. Chair.
Yeah, Senator Peterson.
I call the previous question.
The previous question has been ordered. All in favor of the previous question, which is the first
Mr. Chairman, are
motion
you
to
going to
pass
allow
it by.
anybody to say anything?
It's not a non-debatable question on the pending question. Not debatable. All in favor of ordering the previous question, pending question, previous question, which was Senator Deeds' a motion to pass it by for the year. All in favor of ordering that, vote aye. All opposed, no.
Ayes 10, noes 5.
Ayes 10, noes 5. The previous question's been ordered. The previous question is to pass the bill by for the year with a letter to the Crime Commission to study it.
Mr. Chair.
Yes,
Mr.
Senator
Chair.
Morrissey.
Mr. Chair.
Bunch of wimps.
Mr. Chairman, in order.
Senator Morrissey.
Thank you, Mr. Chair. In order of hierarchy, would it not be appropriate to vote on my motion first to pass it by for the day, followed by passing it by for the year, followed by?
No, the pending previous question has been ordered, and that's Senator Deeds' motion to carry it over for the year with a letter to the Crime Commission. Okay?
Preemptive motion that takes over.
All in favor of that motion, vote aye. All opposed, no.
Ayes 10, noes 5.
Ayes 10, noes 5. The motion carries. The bill will be carried over for the year. A letter will go to the Crime Commission to study it. Thank you, Delegate Levine.
Thank you, Mr.
Appreciate it.
Chairman.
Thank you all for being here. And thank each side for your respectfulness. Okay, now Delegate Levine, you have some other bills.
I have a couple other bills that I think are
Not
hopefully less
controversial, maybe?
controversial. HB 245 is a bill to repeal a very, very old law in Virginia that bans fornication, the crime of two consenting unmarried adults having sex. I don't know how long it's been in the code, but I know that the Virginia Supreme Court has found this law unconstitutional since 2005, based on Lawrence v. Texas in 2000.
Okay, is there a motion that the bill be reported? Is there any discussion?
Mr. Chair?
Yeah, Senator Peterson.
Didn't we have a Senate version? And if so, I move we conform to the Senate version.
What was the
I am
Senate?
unaware of a Senate version.
I don't, just a minute, okay, yeah. Can you close the door there, please? Yeah, okay, yeah. Let's let them out first. Let's hold up for a minute so we can clear the room of those that are not interested in your bill. Yeah.
Thank you.
Okay, go ahead. So you
Yes,
don't think?
I don't believe there is a Senate companion, at least I don't know of one.
I don't think so either. Okay, is there, you're saying this bill is obsolete, is that right? Mr. Norman?
Mr. Chairman.
Yeah.
Down here.
Yeah, okay, Senator McDougal.
I thought Senator Servell had a bill that when we discussed it, we ended up making his
Mr. Chair.
non-possession.
No, that's different, I think.
Mr. Chairman,
Yeah, Senator.
perhaps Kristen would explain the difference between fornication and adultery.
Adultery, you're married, fornication, you're not.
That's
the
correct.
difference. Okay. Is there a motion? It's been moved and seconded that the bill be reported. All in favor of the motion, vote aye. All opposed, vote no.
I would
Ayes
have, but
15, no zero.
You didn't ask me any
Congratulations,
questions.
Delegate Levine, you got a bill.
I have one more bill.
Okay,
Yes.
one more bill.
Mr. Chairman, members of the committee, HB 246 is a bill about police-sworn body cameras. And it specifically says that a locality prior to implementing police-sworn body cameras has to have a written policy. These cameras are very important to the communities that have put them in. Does not require any communities to have them, but they're important because they protect the truth. And therefore, if the police officer is right, the citizen is wrong, it's all on tape. If the citizen is right, the police officer is wrong, it's all on tape. What we don't want is police officers on an ad hoc basis, turning them on or off because that would not cause goodwill feeling in the community. This is designed to protect the community. So all this bill requires is that prior to adopting a new body-worn policy, camera policy, localities adopt a written policy with public comment based on the good guidelines of the DCJS so that they can determine what the policy is prior to implementing it rather than ad hoc afterwards. And I hope it'll be the will of the committee to pass this bill. Yes.
Senator Moore, Delegate, Senator Moore.
Mr. Chair, similar to having written policies for roadblock stops, which make it universal throughout the Commonwealth, this bill is a common sense bill. I would encourage the body to support it, and I move to report.
Mr. Chairman.
Yes, Senator Stewart.
Thank you, Mr. Chairman. Delegate Lean, I'm confused. The sheriff, and I'm speaking of a sheriff in a community, is a constitutional officer elected by the people in the county. Why are you giving authority to the locality to determine the sheriff's policies?
So I actually have John Jones here from the sheriff's office to speak to this bill.
If that's the way you explain the bill, if that's, the county doesn't get to decide a constitutional officer's policies.
Well, the policy would be for police, it would be for sheriffs, it would be, certainly I would expect the sheriff to work with the locality to figure out the policy. But this would be something that they would work on together based on the guidelines.
Well, Mr.
But
Chairman,
if
Senator Stewart.
Mr. Jones.
Doesn't that, why not let the sheriff do the policy? It intrudes on the sheriff's authority to give that authority to a county, a locality. Sheriff is a constitutional officer duly elected in their own stead.
Yeah. All right.
So I'd like to actually, Mr. Jones, if I could, ask him to answer that question.
Okay. Yeah, John Jones, can you answer the question? Here he is, representing the sheriffs.
There you are.
Okay, Senator Stewart. Go ahead.
Good morning, Mr. Chairman and members of the committee. We do support the bill. It's a bill about transparency, and all it says is you do not have to have a body camera. It doesn't mandate it. But if a law enforcement agency has a body camera, then there should be a policy that's made public. And I don't see the local governing body involved in it. It talks about the law enforcement agency. So we support the bill, and it even provides for a assistance using guidance from policies already in place by DCJS as guidance.
Public comment and review as well.
Right, it provides it to law enforcement agencies will make it available. It's about transparency.
Okay, Senator Stewart.
I apologize. The way the gentleman described the bill did not match up with the bill. It does not give the authority to the locality.
Okay. It's a sheriff.
All right. Senator Norman.
Mr. Jones, before you leave, I am certain that you recognize the constitutional sovereignty of a sheriff and that it cannot be usurped by local ordinance. You believe that?
Yes, sir.
Okay. Patron, please.
May I respond? I do apologize
My
for misstating.
My question to you, please, sir, is why are we putting this out for public comment?
I'd be happy to answer that question. May I first address Senator Stewart's question, because I have the language in the bill. I just want to be clear, because I wasn't clear before, and I apologize for that. It's line 254. It says, no law enforcement agency shall adopt this policy unless the agency has adopted a written policy. So it's not the locality, so I apologize there. Mr. Chairman, to answer Senator Norman's question, I think it's important that the public have buy-in for this kind of a system. It doesn't require a lot. It requires public comment and review. But the purpose of body-worn cameras is to persuade.
I appreciate your answer.
Okay.
Thank you.
Okay, all right. Any further questions?
Mr. Chairman.
Senator McDougal.
If I'm just trying to make sure I understand. So this actually does two things. It says, one, somebody's creating a model policy. Is that who's creating the model policy that then the local agencies are going to have to follow in some form or fashion?
So, Mr. Chairman, the Department of Criminal Justice Services has already adopted a model policy that they worked on for more than a year. Secretary Moran could talk about the details of that, but they've already gone through it in some detail, taking a lot of stakeholders. And the local law enforcement agency does not have to follow that policy. They use it as guidance for their decision.
Okay, all right. Any further questions? Is there a motion? Yeah, Senator Morrissey.
Mr. Chair, with regard to Senator Stewart's comments, this legislation, proposed legislation, just mandates that the locality establish a written policy. The sheriff is going to be involved in that written policy, and it has the opportunity to use the model already established by DCJS. And I might add that our sheriffs throughout our 138-plus localities regularly and routinely adopt written policies based on other model guidelines. This is not something new or unique.
Okay, any further questions? Is there a motion? Yeah, it's been moved to report and seconded by Senator Deeds. All in favor of the motion to report the bill, vote aye. All opposed, vote no.
Thank you, Mr. Chairman, members of the committee.
14-1, the bill is reported.
Thank you, everyone.
Okay, thank you very much. You're finished for the day. Okay, is there a Delegate Batten here? Okay, Delegate Batten. And you have House Bill, what's your number?
988.
988, House Bill 988, compensating victims of crime. Okay?
Yes. Good morning, Mr. Chairman, members of the committee. House Bill 988 adds grandchildren to the list of individuals who can apply for benefits from the Virginia Victims Fund, the grandchild of a victim. Currently, the grandparent, the parent, the sibling, or the child of a victim can apply for benefits from the fund. The fund is typically a payer of last resort, and that benefit would typically be counseling, grief counseling services, or funeral costs, burial costs. This matter was brought to my attention after the tragedy in Virginia Beach. There was a nonprofit in the area who was attempting to assist the families, and at that time they realized that grandchildren were not able to apply for those counseling services. I'm happy to answer any questions, and I do have, I believe she's still here, I have someone here from the Virginia Workers' Compensation Commission, which administers the fund.
Okay, somebody from the Workers' Comp. Any questions of the patron? The Workers' Comp, here's somebody coming up. No, is there somebody from the Workers' Comp Commission want to say anything? All right, is there? Okay, all right. It's been moved and seconded that the bill be reported. All in favor of the motion, vote aye. And I'm sorry, and re-refer to finance. Okay.
That's 15-0.
15-0. Congratulations, the bill is reported. Thank you. Now we have Delegate Adams in the queue. You got a series of bills.
Yes, sir. Good morning, Mr. Chairman.
You don't think people ought to spit on the sidewalk? Is this Senate Bill 1070?
Yes, sir.
Okay, you don't think people should spit on the sidewalk?
I don't think it should be illegal.
Okay. Any questions? Explain the bill.
Essentially, the current code states that anyone who spits on a sidewalk or public space where a public may assemble or any part of the floor, or a sidewalk abutting a public street is guilty of a Class 4 misdemeanor. So this bill would strike that language.
Okay. Is there any question about spitting on sidewalks? It's been moved and seconded that the bill be reported. All in favor, vote aye. All opposed, vote no.
That's 14-0.
14-0, bill pass. Did you? Yeah, put her down. She wants to vote yes. For 15-0. Okay. Okay. Is that it? 15-0? Bill is reported. 15-0, the bill is reported. And by the way, the Code Commission that I chair happens to take up bills frequently that are obsolete. So if anybody's got any ideas of obsolete bills, you're welcome to go to the Code Commission and make a suggestion. Okay,
Thank you,
thanks.
Mr. Chair.
The next bill is 1071.
Yes, sir. Thank you, Mr. Chair. 1071 essentially removes public swearing from being a Class 4 misdemeanor. In 1971, this was ruled by the Supreme Court to be unconstitutional, to prohibit swearing, and I would hope that Virginia law would do the same.
What's going to our country? You can't even, you're not even supposed to swear on it. Okay, all right, it deletes the crime of swearing in public. Is there any discussion? Is there a motion? Been moved to report and seconded that the bill be reported. What'd you say, Senator Stanley? What'd you just say, Senator Stanley?
Goodness.
Mr. Chairman.
Yeah, Senator McDougall.
Mr. Chairman, this question is maybe for Mr. Benjamin. I'm moving a little slow this morning, but refresh my recollection. Has it been interpreted that usually I hear judges say it, whether that it's correct law, that the profane cursing is tied to the intoxication in that drunken public statute?
It's not.
Cursing abuse.
Mr. Chairman, Senator McDougall, I think what you're correctly saying is that the statute, as it's currently being enforced, is limited to public intoxication. You cannot, and the patron is correct, you cannot criminalize cursing.
It says
I'll note,
curse or swear.
I'll note in addition that we do have 18.2-416, which makes it a Class 3 misdemeanor, more serious than the provision being repealed for using what amounts to fighting words, and that is constitutional.
Okay. All right. Is there a motion? Moved and seconded that the bill be reported that takes out the crime of profane swearing in public. All in favor of the motion, vote aye. All opposed, no. Huh?
Pass 15-0.
Who votes twice? Sasslaw votes twice? Okay. From now on out, you can swear. Okay.
Thank you, sir.
All right, thank you. Senate Bill, House Bill 1076, Delegate Adams' bill, carrying concealed weapon sling bow. What is a sling bow?
Sir, a sling bow is a cross between a slingshot and a bow and arrow. A handheld sling bow would look like this, which this is a chamber for the arrow that attaches to the end. This is a more sort of elaborate wrist model, whereas a slingshot is really something that many of us had in our childhoods, which is a forked stick and a elastic band. The purpose of removing this is in looking at all of the other instruments. From what I could find, all of the other instruments are prohibited for sale, not including the gun, but in that particular section. It is an escalating charge. So if you had a slingshot in your back pocket and your T-shirt is over that, it goes from a misdemeanor to ultimately a felony if that happens more than once. So that is part of the bill. The other part of the bill, while in that part of the code, removes the harbor master of Hopewell as the one member who would have an exemption to carry all weapons.
Well, let's go to the first one. You changed slingshot to sling bow.
Yes, sir.
On line 16. That is, you got to have a concealed weapons permit to carry. Is that right?
Yes, sir.
Okay. All right. Any question on that first? Yes. Yeah. All right, Senator Peterson.
Okay, I got to ask, you struck the harbor master of the city of Hopewell.
Yes,
from
sir.
the, and I may be the only one who knows this. I remember when he was actually put in there. I think it was 2002, and I think it was Delegate Ingram's bill. But I always thought it was unusual we have one person. Any reason why we're taking him or her out now?
Yes, sir. Mr. Chairman, the harbor master of Hopewell is a non-existent position. But I did hear from a rumor that Senator Stanley was looking for property there, so he could run for that.
Senator Norman.
Question, Mr. Chairman, is a little more technical. How does this pass the single object rule that's embedded in the Constitution?
I cannot answer that.
Well, it's the same section of the code, oddly enough.
No.
All right, is anybody here to speak for the harbor master?
Mr. Chair. Mr. Chair,
Yes, Senator Peterson.
I'm going to move to report and speak to the motion. First of all, I've never thought slingshot should have been in that code section, but sling bow seems more appropriate. Secondly, I always thought it'd be easier to list the number of people that had to qualify for concealed carry rather than, we had so many people that were exemptions. So I think it's good if we take one out, at least in this case. So I'll move to report the bill.
Okay. It's been moved and seconded that the bill be reported. All in favor of the motion, vote aye. All opposed, no. Okay. Voice go? All right.
No, I don't have Boy Scouts. I had Fast Paw. It's Marcy.
Okay.
Ayes 12, noes 3.
Ayes 12, noes 3. The bill is reported. Okay.
Thank you, Mr. Chairman, members.
And thank you, Delegate Adams. Appreciate it. The next is Delegate Carol Foy. Is she here? Oh, there she is. Okay. And this is House Bill 923, having to do with alcoholic beverages.
Good morning, Mr. Chairman and members of the full committee.
Good morning.
House Bill 923. The problem my bill solves is that the Fourth Circuit Court of Appeals in Manning versus Caldwell in 2019 just ruled that Virginia habitual drunkard scheme or law is unconstitutional because it is vague and it has a disparate impact on the homeless and people suffering from the disease of addiction, making enforcement arbitrary. So interdiction dates back to the 1800s. Only Virginia and Utah, the only two states in the nation who has it. There's been over 4,743 convictions since 2015 that was counted of interdiction persons. So what interdiction is that a person can just be said to be a drunkard. There's no definition of it. A petition can be made to the civil court. The defendant doesn't or respondent doesn't have to be there. They don't have to be represented by counsel. And once they're deemed interdicted, they can never again purchase or possess alcohol. And so I brought this bill as a public defender representing people who are over 100% under the poverty line, seeing this being used as a way to address addiction is completely unethical and wrong. And so to bring this legislation to repeal just the habitual drunkard section is what this bill does.
Okay, any questions of the patron? It's been moved and seconded that the bill be reported to delete habitual drunkard from the code. All in favor of the motion, vote aye. All opposed, vote no.
Ayes 15-0.
15-0. Thank you, Delegate Foy.
Thank you, Mr. Chairman. Thank you,
Appreciate
members
it.
of the full
Thanks so
committee.
much. All right, the next is Delegate Bagby.
Good morning, Mr. Chair, members of the committee. My bill, House Bill 787, is a bill that would add hate crimes to the list of offenses for Virginia multi-jurisdictional grand juries in which they can investigate and prosecute when the crimes are committed due to the victim's race, religious conviction, gender, disability, gender identity, sexual orientation, color, or national origin. And it's 2 lines being changed, pretty simple, but
Mr. Chair.
pretty impactful.
Mr. Chair.
Senator Peterson.
I'm just flipping through all the legislation, and I see that Delegate Mullen has a bill which would basically void, it would essentially allow a multi-jurisdictional grand jury for any crime under 18.2, I think. I mean, he's here in the audience. So I don't see, we either roll one into the other, or, I mean, if it's available for every crime under 18.2, it would cover hate crimes, correct?
Yeah. I think Surveyor wants to talk to you. He's trying to talk to you.
Yeah.
If you all intend to pass that, then I will.
Senator, we cannot incorporate 2 House bills. Okay.
Okay, well, I guess the question is, we can't pass them both, and so I don't know why y'all passed them both, but maybe we'll see which one we want.
Okay, you have somebody speak in favor of the bill?
I believe you have a number of people here.
Somebody, all right, who wants to speak in favor of the bill? We got a bunch of them or not? Okay.
Good morning, Brittany Whitley with the Office of the Attorney General. This has been a priority for Attorney General Mark Herring
for the last 5 years, as hate crimes are on the rise continuously in the country and throughout the Commonwealth. We would like more tools to investigate and prosecute those. The Attorney General's office does work within the multis as a partner. We don't have original or concurrent jurisdiction that's offered by those. And we do participate within the 18 multi-jurisdictional grand juries. And we think this makes sense to fit within the multis because a lot of the crimes that are already covered by those are related to organized crime and violent crime, which is what a lot of hate crimes are. Thank you.
Mr. Chairman.
Senator Morrissey.
Brittany, I support the legislation, but tell me why, what was the genesis behind this bill? Why do we want the multi-jurisdictional grand jury to now have the authority to investigate this as opposed to each individual constitutional officer, the Commonwealth's attorney?
I think it really came down to a resource issue. When about 5 years ago, when we started to see a rise in hate crimes, our office tried to give some thought to how we could be a better resource for local law enforcement, and we thought that adding hate crime to the multis would allow us an avenue to offer resources to local law enforcement to help prosecute and investigate those, rather than giving us something like an original or concurrent jurisdiction. We're already formally within the multi-jurisdictional grand juries. And so that just allows us to be a partner for them in an already established setting.
Okay. All right. Any other questions? Is there a motion?
Mr. Chair.
Yeah, Senator McClellan.
My understanding is that the two bills are not in conflict, and we have on multiple occasions passed a narrow bill and a broader bill in case something happens between here and the governor's office. So with that, I would move to report.
Okay, we're dealing with this bill now. Okay. Been moved and seconded that the bill, House Bill 787, be reported. Any further discussion? All in favor of the motion, vote aye. All opposed, no. Louise Sasslaw? They're not, okay. Okay.
I 706.
706, the bill is reported. Thank you very much.
Thank you, Mr. Chair, members of the committee.
While we're at it, yeah. You want to vote yes? Yes. Okay. All right. The 9-6, the bill passes. Yeah, no. Would you like to, let's do this. Is there a motion to reconsider the vote?
Yes.
All right, second, all in favor of the motion to reconsider the vote? All in favor, aye. Aye. All opposed, no. Is there now a motion to report?
Move to report.
Been moved to report. Is there a second? Second. All in favor? Is everybody here and everybody's got the proxies? All in favor of the motion to report House Bill 787, vote aye. All opposed, vote no.
Ayes 906.
Ayes 906, the bill is reported. This here, now we're at it with the same subject matter, Delegate Mullen, and then we'll go back to Delegate Price and the others. All right, because we're dealing with the same sort of general subject matter. Delegate Mullen, you want to have the grand jury, multi-jurisdictional grand jury apply to everything, right?
Well, thank you, Mr. Chair. I love Christmas trees, but it's not Christmas right now. With the excellent bill that you just passed, there are now 43 exceptions to when you can use a multi-jurisdictional grand jury. At this point, there are more things you can than things you can't. This bill simply just says, if it's a crime, you can use a multi-jurisdictional grand jury.
Any questions?
Mr. Chairman?
Yeah, Senator Morrissey.
Delegate, initially when multi-jurisdictional grand juries were created, it was to investigate a crime that went over jurisdictional lines, like drug trafficking. And it was considered that prosecutors from several jurisdictions were better able to get together and bring the information before a multi-jurisdictional grand jury, like drug trafficking. I'm not saying that I'm opposed to this, but why are we now, what is the purpose or the reason to have the multi-jurisdictional grand juries have authority over every possible criminal code violation?
Well, my experience has been, as a prosecutor who's handled multi-jurisdictional grand juries for years, that they are a limited tool that can be utilized in times, as you said, that cross jurisdictional boundaries. And in all frankness, you can now use them for so many different things. It seems unusual that you can't use them for something. They're not used every day. Most jurisdictions don't even have a multi-jurisdictional grand jury. The places that use them most frequently are in Hampton Roads because you can, within 25 to 30 minutes, be in all 7 cities. And so crime sort of passes about in that fashion.
One follow-up question. Mr. Chair.
Move to report, Mr. Chairman.
Hold on a second.
Mr. Chair, follow-up question.
Yeah, Senator Morrison.
Trying to cut him off.
Recently, we had, and I'll give an example that's in everybody's minds, gray machines. We had prosecutors in one jurisdiction that said, nope, it's legal, in the contiguous jurisdiction, illegal. If a prosecutor now in the, say, for example, the city of Richmond says it's illegal, would this same matter be brought before, couldn't it be brought before a multi-jurisdictional grand jury? And for an offense that occurred in Richmond, where the constitutional officer said, I'm not going to prosecute it, it's legal, the multi-jurisdictional grand jury could bring an indictment against a store owner in Richmond who has these machines?
Mr. Chair, I would say to the senator, no, because the constitutional officer of Richmond is still the chief prosecutor and chief law enforcement officer. And so while you could, from an outside jurisdiction, in theory, approach that, you're not going to be able to prosecute a felony without the Commonwealth's attorney of that particular jurisdiction.
Let me
Mr.
ask
Chairman.
you,
Mr. Chairman.
Senator Stewart.
I came in late, and when I read the bill, it worried me so much I felt like I needed to speak to it. The grand juries were set up in Virginia to be a safeguard against overzealous prosecution, people getting indictments where they shouldn't be getting them. Unfortunately, this regional grand jury, and these multi-jurisdictional grand juries originally started for drug cases that crossed jurisdictional lines. In my experience, and I've been practicing in this area for over 25 years, that multi-jurisdictional grand juries become nothing more than a rubber stamp of an indictment that a prosecutor wants to get. And it's very concerning to me that we would open this up to any law in the Commonwealth. In the counties, we have a special grand jury, we have the regular grand jury, and so if you want to investigate something in your county or potentially otherwise, you can impanel a special grand jury if you don't want to do it before the regular grand jury. But it's very concerning to me because I've seen the mischief come out of these multi-jurisdictional grand juries that I hope that we won't support this bill. And as much as I like my friend who's an outstanding prosecutor and outstanding attorney, this bill gives me great pause, and I move to pass it by indefinite.
Mr. Chairman.
Yeah, Senator McDougal.
And this is for Mr. Benjamin. If I understand correctly, the multi-jurisdictional grand jury could issue an indictment even if the Commonwealth's attorney of a particular jurisdiction was not necessarily in favor of moving that forward, and a person would have to go through and prepare for their defense even if the prosecutor ultimately decided to move forward. Is that not accurate?
That's correct, Mr. Chairman.
Senator
Mr. Chairman.
Senator Steve Benjamin.
Mr. Chairman, I'd just say, I clearly understand, and I've probably added to this Christmas tree along the way, but I do have the same concerns that the tree is probably too large as it is now, and we have a lot of other tools, certainly with technology and communication. There's the ability to prosecute crimes, and we need to make sure that the prosecutors in the jurisdictions are making the decisions.
Mr. Chairman.
Delegate Mullen.
I would just say there's a reason why we had the small bill and the big bill. If people don't like the big bill, I'm glad that we were able to add now our 43rd exception to the list. So.
Steve Benjamin, Councilman Benjamin.
Mr. Chairman, for probably the past 15 years, I've been suggesting that this bill would be appropriate because of the expanding list. I'll note that Senator Stewart has always been a strong advocate for the grand jury protection as originally envisioned. The problem is that grand juries in current practice, both multi and regular grand juries, are just the rubber stamp that Senator Stewart references. The advantage, I need to point out for the committee, to multi-jurisdictional grand juries, and I've never been a fan for the reasons that Senator Morrissey expresses. A grand jury in a particular jurisdiction should have the sole power, I've always said, to indict so that it reflects the values of that community and not a broader community. Nevertheless, one of the advantages to the multi-jurisdictional grand jury, again, is because of work that Senator Stewart has done in the past. That's on lines 53 and 54. So if a multi-jurisdictional grand jury is used, then there must be a court reporter who prepares a transcript that is then available to all of the parties. And it is through that transcript that I can tell you a number of abuses have been detected and dealt with. Regular grand juries don't create a transcript. So oddly enough, I have to tell you that the multi-jurisdictional grand jury, for all you might criticize it for, actually provides better protection for an accused because it gives you an opportunity to read what was presented.
Would the solution, counsel, be a bill that would require all grand juries to have a court reporter? That would be the solution.
That sounds like a pretty good bill.
That would be a wonderful bill.
Yeah,
That's
I would certainly vote for that bill.
I've never, Delegate, I've never been a huge fan of multi-district grand juries. Sometimes in discrete situations, they work well, but I'm not in favor of this bill. So anyway, is there a motion? I made a motion. Has the motion been made to pass the bill by indefinitely?
Mr. Chairman, if we did pass it by indefinitely, could there be a letter that goes from the chairman to DCJS, for example, that they study it? Because I've listened to staff, Mr. Benjamin and Senator Stewart, and there's pros and cons for both position. Is there a mechanism that we can study this if we do pass it by?
All right, want to send it to the Crime Commission?
Beg you, I'm sorry?
Yeah, letter to the Crime Commission?
Certainly.
All right, the motion's been made to pass the bill by indefinitely with a letter to the Crime Commission to study this matter. All in favor of the motion, vote aye. All opposed, no.
I still think those two.
13 to 2. Okay, thank you, Delegate Mullen. And
I think you are as well.
do you have any others? Yeah, you have some more. Yeah, let's go ahead and get rid of all of yours.
Keep running through. Yes.
Yeah, there's Senate Bill 475, Sexual Assault Forensic Examiner Coordination Program.
Thank you, Mr. Chair. I believe that there's a prepared substitute. Is that correct? Or since we passed it in the House, we don't need to do anything different? 475.
Mr. Chair, this is similar to Senator Deeds' Senate Bill 373. The lone distinction is in Delegate Mullen's bill, after the word survivors, there appears the words of sexual assault. That is the two differences between the two bills.
That's correct, Mr. Chair.
And the finance clause.
Okay.
Well,
yes.
I will just say that we included the cost of this within the House budget. I do not know if it was included in the Senate budget.
Does not need to go to finance. Okay. Okay. Is this conformant to
I move we
Senator Deeds?
conform it to the Senate bill and
All
support
right.
it.
Is there a motion to conform? All in favor of the motion to adopt the substitute, vote, say aye. Aye. All opposed, no. It's been moved and seconded to report the bill. All in favor of the motion, vote aye. All opposed, no.
Ayes 15-0.
It's 15 to 0, okay? Senate Bill 666, vital records.
Thank you, Mr. Chair.
Oh, okay, I'm sorry. That bill will be referred to Ed and Health. Is there a motion that we re-refer the bill to Education and Health Committee? All in favor of the motion, vote aye. We have to vote, don't we? All in favor of the motion to refer, vote aye. All opposed, no. Okay. Okay, it's been re-referred to the Education and Health Committee. Is that all your bills?
No, Mr. Chair, we also have Senate Bill 666, referring to the definition of a dead body. Oh, that's the one we did? Oh, okay, all right, well, then I think I'm done.
Dead bodies go to Education and Health. That's where they're buried.
Thank you, Mr. Chair. Good to see you.
Okay, thank you. Okay, the next is Delegate Price. And Delegate Price has,
Good morning.
see, where's your bill? What's your number? 422, Youth and Gang Violence.
Yes, Mr. Chairman and Senators, House Bill 422 would establish a youth and gang violence prevention fund and grant program and would allow for $25,000 for 6 localities, Hampton, Newport News, Norfolk, Portsmouth, Richmond, and Roanoke, to perform independent community assessments to determine which youth and gang violence prevention programs are working and what can be improved. These assessments are a part of the Youth Promise Act that seeks to prevent youth violence, gang-related crime, and juvenile incarceration. And this act was passed as part of House Resolution 5963 by Congress, but it was not fully appropriated. So these funds would allow the 6 localities to begin their work.
Okay, good bill. Is there any discussion, any question? No. It's got to go to finance. Okay. All in favor of the motion is there a motion to report and re-refer to finance? Been moved and seconded. All in favor of that motion, vote aye. All opposed, no. Motion carries.
Thank you.
Good, thank you, Delegate Price. Thanks so much. Okay, the next is Delegate Simon.
Mr. Chairman, I apologize. Can we, having voted on the prevailing side, can we reopen that so I can vote for Senator Boysko?
All right, he's going to take care of that. Okay, Delegate Simon, your bill is number?
Delegate, my bill is House Bill 790. This is a bankruptcy bill, and this would.
We have a substitute.
I don't have a substitute. I hear you might have a substitute.
Yeah. Okay. We have a proposed substitute. You got to explain the bill.
All right. Well, my bill would have done, the one that came out of the House was increase the homestead exemptions only on your primary residence. Increase the homestead exemption to $25,000. Tag that amount to inflation going forward, so we wouldn't have to keep coming back here every 10, 12 years and saying that the amounts come out of date. Eliminates the requirement to file a homestead deed if you filed for bankruptcy under Chapter 11, since there is a record of that for the world to see. And then allows you to reset your wild card exemption every 8 years. So that if you, I think we originally had it at 7, so we had it at 10. So that's essentially what the bill does. It's mostly to address the issue of the homestead exemption on real property, so that you can have a meaningful exemption to protect your equity in your home through the bankruptcy product.
We do have a substitute. If you haven't seen the substitute.
Somebody showed it to me over on the side.
Okay. Yeah. Is there a motion to adopt the substitute?
So move.
Is there a second? All in favor of the motion to adopt the substitute, say aye. Aye. All opposed, no. Now, one of the problems with the original bill, the Code Commission shouldn't be in there.
Because you don't want them being the ones to figure out the
No,
the
they don't do
reset.
that. They don't do that.
Okay.
And the second problem, I think, is having somebody having to go back and check the CPI all the time, and that seems to be very cumbersome. So anyway, we have a substitute here.
Okay.
You want to have some speakers to come up and speak to the substitute and or the original bill?
Mr. Chair?
Yeah, sir.
Could you make sure Mr. Press has a copy of the substitute?
He does.
You got it? Okay.
I do have a copy of the substitute.
Okay. Okay.
So,
right up.
Do you want me to tell them what the substitute does, or do you want to tell? I mean, like I said, I just saw it. I understand the difference mostly is that you guys, rather than having the 25,000 specifically tied to the real property, make that the new larger wild card. We don't tie it to inflation, so we'll have to come back as necessary to raise it. And is that essentially the big difference?
Mr. Chair?
Pretty much, yeah. Senator Peterson.
And I hear this I'm going to ask Dan directly. The wild card, what does that mean, the wild card, for those of us
All
who
right.
don't do bankruptcy?
So, Mr. Chairman, my name is Dan Press. I'm a bankruptcy lawyer in Northern Virginia and member of the board of the National Association of Consumer Bankruptcy Attorneys and with the Virginia Association of Consumers and Bankruptcy Attorneys. To Senator Peterson's question, the way the so-called homestead exemption works right now is you have a $5,000 exemption that can be used for anything. It's used for residence, used for money, used for extra equity in a car, whatever. And that, Virginia is the lowest state in the country for a homestead. We have actually zero protection if you consider that most states have some kind of a wild card available for some money in the bank and that sort of thing. So we have zero protection. So what we were trying to do with this bill is create protection for the residents, the principal residents, so the creditors couldn't take your house over a relatively small amount of equity that, creditors or bankruptcy trustees couldn't cost you your house for medical bills or that sort of thing. The substitute, frankly, the substitute accomplishes that goal. It does protect the house, but it also then allows that to be used for anything. And, frankly, I think, I think us bankruptcy lawyers and our clients would probably like it. I think the banks and the collection side of the universe would not. And this was actually a relatively carefully crafted compromise with initially with the Virginia Bankers Association, so that we've been trying this for several years, and we've finally come to an agreement with the Bankers Association that
Can I ask a
get the
question?
25. Yes, sir.
Mr. Press, I apologize.
Senator
So it's 25,000 in cash. So in other words, if I have a judgment for, say, 23,000 against a debtor, does this mean I can't garnish his bank accounts, or what does it mean?
No, the judgment size is irrelevant to what you can protect. So it's how much asset they have. So right now, if you had a judgment for 23,000 and they had a bank account with 3,000 in it, you could take the 3. If they had a bank account with 8,000 in it, you could take the 3, and then they would use up the 5 protecting that. Right? Now, if your judgment was 3, you can only take 3, but if it's 23, you can still only take 3 because that's all that's there over and above the exemption. You could be $1 million judgment. You can't collect what they don't have, right? But this is a protection for allowing the debtor to keep a certain amount of property which they need to get a fresh start. They need to pay their rent, pay their utility bills, that sort of thing. And what we're trying to do is keep them in their house, unless there's so much equity in the house that it really is fair for the creditors to be able to take it.
You can collect whatever you can collect, but 25,000 is set aside so they can basically stay alive or.
Exactly, from the house, right. And the substitute would allow 25,000 across the board to be set aside. We also had indexing in there. I understand Senator Edwards has a problem with the indexing. Frankly, I can live without indexing for now. We may need to be back in a few years if we have some inflation, but so be it. But I would suggest that the committee not adopt the substitute on the 25,000, because I think, and we've spoken with the creditors' attorneys representative is here today. We've spoken with them, and they're in agreement with that. The banks were in agreement with it, and I think this amendment does disrupt
All right, how about this?
careful
Anybody else
compromise.
want to speak in favor or against?
Good morning, Mr. Chairman. Darden Hudson, colleague with Dan Press. Just real quick, I would ask that the committee decline to amend the House Bill 790.
Who do you represent, by the way?
I'm with the Virginia Consumer Bankruptcy Association.
Okay.
Bankruptcy
Creditor
Attorney
side,
Association.
defense side?
Debtor side.
Debtor side, okay.
The amendment and the bill update both the numbers and the scheme I appreciate that the amendment updates the number, which has not been updated since 1978. The homestead and exemption scheme, which really has not been updated since 1936, was addressed in the rest of the bill. The 25,000 change, I think, will be opposed by the other stakeholders in the process, and I'd ask that the House Bill 790 be considered as drafted.
Mr. Chairman?
All right, yeah,
Can-
Senator McDougal.
Can I ask him a question?
Yes.
And I'm not as familiar with this area as I maybe should be, but if I'm looking at substitute lines 169 through 72, that last paragraph, does that reset this exemption every 8 years? So every 8 years you could get a new 25,000 that creditors could not go after?
Under the amendment, yes, the original bill reset it every 8 years. Virginia's the only state in the union that, currently it's a lifetime cap. Once you use it, it's gone. Virginia's the only state in the union that has any kind of a time cap like that. We compromised with the creditors bar and the bankers to make it 8 years, which is the time between possible Chapter 7 bankruptcy filings. In the rest of the country, these exemptions exist, day to day, basically. And there's no cap nor a reset.
Mr. Chairman.
It would reset.
Senator McDougal.
So under your original version, you had 25,000 for homestead, and then that could be reset every 8 years, in addition to the, I guess, 5,000 for other personality, whether it's cash or a car or whatever, other assets. Under the substitute, it's 25,000 homestead, 25,000 cash, car, whatever, and that resets every 8 years. Am I understanding that accurately?
I did just look at the substitute, but the original bill has 25,000 in equity and principal residence.
How many people want to speak for this, how many people against the substitute? Raise your hand. All right, anybody like the substitute? Why don't we do this? Can we, got other things to do, pass it by for the week and come back next week? So y'all sit down and figure this thing out. Not many people up here know much about bankruptcy. I've done some bankruptcy work, but not a whole lot.
We'll work it out.
Okay, all right. Well, if, without objection, go by for the week. Okay, thank you.
Thank you.
All right,
Thank you, Senator.
Yeah, thanks so much. All right. The next bill is Senator Delegate Hope. Now, Delegate, we have, let's see, Delegate Hope's House Bill 600 is going to Rehab and Social Service. Is there a motion to transfer 600 to Rehab and Social Services, to refer it, all in favor of the motion to refer to Rehab and Social Services, vote aye. All opposed, no. Okay. And then there's
14-0.
14-0. Then you have another one, which
I have
is
two bills, Mr. Chairman,
Okay.
remaining, 331.
331.
Yeah,
that-
this is more of a clarification in the code. What it does is it specifies that a particular diagnosis shall not be allowed as sufficient evidence that an individual is incapacitated. Sometimes when you get labeled that you have dementia, the courts will automatically say that you are incapacitated. And we know there are all different levels of incapacitation within dementia. And so this doesn't automatically mean that you are labeled that incapacitated. So the language clarifies that a diagnosis does not arrive you at that.
Is the bill really necessary? I guess that's one question.
Well, it is, because we have found that some courts, when you get labeled to have that diagnosis, that they label you as incapacitated.
What do you think?
And so this is a clarification in the code.
Mr. Chairman,
Yeah, Senator Serval.
a question for council. Didn't we already pass this? Or did it come through a different committee and pass the whole body, am I imagining?
If you look at the preceding sentence, Mr. Chair.
Yes, Senator Peterson.
Delegate Hope, it looks like this preceding sentence basically says the same thing. The preceding sentence says, a finding that the individual displays poor judgment alone shall not be considered sufficient evidence that the individual is an incapacitated person within the meaning of this definition. And then the sentence afterwards, your language, a finding that the person is incapacitated shall be construed as a finding that the person is mentally incompetent. I guess we keep telling people what a finding is. Are these all consistent statements? Are they inconsistent?
Mr. Chairman, they would be my sentence that where many has to do with the diagnosis itself, and the preceding one has to do with display and poor judgment. But you can get a diagnosis from a physician, but that doesn't necessarily mean that you are incapacitated.
Mr. Chairman?
Yeah, Senator Obenchain.
It works.
Either way.
So is there a particular case that you can point me to?
I can't point you to the cases. I was brought this by, or we have a Northern Virginia AG network, that this has been one of their.
Aging network?
AG network, in North, if you're in Northern Virginia, you know what this is. And so they had seen circumstances where this had occurred, and they just wanted to make sure that we clarify in the code that just because you get this diagnosis does not necessarily mean that you are incapacitated.
Let me, Mr. Chairman.
Senator Obenchain.
And a couple of thoughts. I can't imagine a court actually making that finding. I mean, knowing the gradations of dementia, and I agree with you in principle, but when we think also on the flip side about financial exploitation and exploitation of seniors in particular, I know the Supreme Court has made it clear that even having dementia or Alzheimer's doesn't mean that you are incapacitated or incompetent to make a will. Even if you have a guardian, you're not incompetent to make a will. But I would worry that something like this might make it, I don't want to do something that's going to make it easier for people to exploit elders.
Mr. Chair, let me I'm going to sort of play this out in a practical. If I'm challenging a will, or I'm challenging some contract that was executed by a client or a family that has someone that has Alzheimer's, a grandmother, for example, and I put on a treating physician, and they say, Mrs. Smith, in my opinion, was not mentally competent or was not exhibiting, property decision-making. And if I put on that expert testimony, is that not going to be sufficient? Is the judge going to have to look at this code and say, sorry, that's not going to be enough, and so that check she wrote for $10,000 for something that really cost $1,000, that's my worry, that we may be putting ourselves in a position that now we can't prove capacity where we need to prove it.
Well, Mr. Chairman, are you saying, just to clarify what your example, are you saying that if someone goes into court and says they have dementia or Alzheimer's or some other cognitive disability, that is by itself alone enough to label them incapacitated?
No, well, they're going to have to bring in an expert witness. What my point is that this litigation typically comes about where a concerned family member or somebody else files a petition to have a guardian appointed or to void a contract. Had it happened in my own family, you have an elderly family member that's suddenly writing checks left and right that make no sense. You go in to get control of the checkbook, you try and void transactions which were clearly, taking advantage of an elderly person, and you have to go get a neurologist who can say, that woman, or typically a woman, but that man is not in their correct faculties. But I'm worried that if we pass this bill, we're now saying that testimony is not going to be sufficient evidence, and those transactions will stand.
Okay,
Chairman, I think we're saying just the
So,
opposite.
let him speak. Go ahead. You want to answer the question first? You want to answer Peterson's question first?
Mr. Chairman, I think we're saying just the opposite, that if you have a diagnosis of Alzheimer's or dementia, that does not mean just because you have that diagnosis that you should be declared incapacitated.
Well, Mr. Chairman.
Senator Obenchain.
So what if all you have is a diagnosis of advanced, intractable, irreversible Alzheimer's? I mean, shouldn't that alone be adequate to establish incapacity?
Mr. Chairman, I think there are all kinds of variations on the spectrum.
But what if all you have
Alzheimer's.
is that Alzheimer's diagnosis?
I don't think, Mr. Chairman, I don't believe that should be enough.
Yeah, is there somebody who wants to speak?
Wow.
Are you in favor? Yeah, go ahead, state your name.
Yes, Mr. Chairman, Carter Harrison from the Alzheimer's Association. In order to get a diagnosis of Alzheimer's, you're going to have observed behavior and medical testing. So you'll be able to submit that information. That's more than just the diagnosis itself. So while we didn't bring this bill forward, we do support the concept that just because you have Alzheimer's doesn't mean you're not competent to make decisions. And
But isn't it true, though, that a trier of fact's going to check into that? I mean, if somebody is, Alzheimer's just getting started, not advanced, maybe they could still make decisions, and the trier of fact could figure that out, couldn't they?
Yes, sir, that's exactly what I was saying. Yes, sir.
Okay, so you don't need the bill.
Well, Mr. Chairman, I didn't bring the bill, but on behalf of the folks that did, when they brought it to my attention, they pointed out that there were people that were being sent through the guardianship process on the diagnosis alone.
Okay.
Any diagnosis.
Yeah.
But
Senator Obenchain.
But what I'm not hearing, and I don't question the motivations, what I'm not hearing is that anybody is going through the guardianship process and getting the wrong result. I think I've got enough confidence in our judges and special justices who make those determinations that I'm afraid of removing this as an element of discretion. And, I think the system probably works. And until you bring me something saying it's not working, that people are being subjected to unwanted and unnecessary guardianships, not proceedings, but guardianships, I'm pretty reluctant to.
Yeah. Anybody else? Senator Morrissey.
Mr. Chairman, Patrick, you have always been a champion of the little guy, the person watching out for those rights. But I'm mindful of my father, who was at end-stage Alzheimer's, and that was he was as strong as a horse, and he could do everything else so well, but that one diagnosis of Alzheimer's really prevented him from handling so many different things, and I'm concerned that that language would prevent that from coming to fruition. That's my concern. And
Mr. Chairman,
Senator Hope.
Delegate Hope. You would still have to have the fact finding whether that person is incapacitated. But just the diagnosis alone, just because very clear, maybe my mother has dementia, and she is at early stage. She has complete control of her faculties, and she is not labeled incapacitated. But I would hate to be in a circumstance because she's got the label of having dementia that she's suddenly incapacitated. And I'm bringing this bill. Now to Senator Obenshain's point, I'm bringing this bill because others have come to me and said that this is a concern that they have seen. I have not seen it for myself, Senator, so I can't cite any cases. But that's why they're bringing it, is because they don't want it to be automatically the case that you're incapacitated just because you have the diagnosis.
Senator Chafin.
Yes, Mr. Chairman. So the vast majority of these cases, in my experience, over 90%, they come to court with a petition for the appointment of a guardian or conservator, and they get there on a medical report. They get there from a letter as provided in the code that has a diagnosis in it. Okay, and in that diagnosis, and that is enough for most circuit court judges in the absence of some other evidence. So I think this will have a chilling effect on how the vast majority of these are handled, because there may not be other family members. There may not be other people who are stepping up and doing anything, and the Department of Social Services is coming in these cases and is getting a guardian appointed, getting somebody appointed because they're subject to elder abuse or subject to manipulation in some way.
It could have, in other words, it could have just the opposite effect of what you want it to have. Okay. Anybody else? Is there a motion? Any discussion? Is there a motion? No motion.
Mr. Chair.
Mr. Senator Peterson.
And I recognize what Delegate Hope is doing. My concern is, if we add this language to the code, we may tie the hands of a judge that in a petition case really may need that diagnosis to rely on. I agree it's not solely, and I agree it's a rebuttable, but my concern is the chilling effect. So I'm going to move to PBI this bill.
Is there a second?
I'll second.
It's been moved and seconded the bill be PBI'd. All in favor of the motion, vote aye. All opposed, no.
Ayes 11, noes 4.
11 to 4, the
One
motion
more.
carries. Yes, Senator, Delegate Hope.
House Bill 651.
House Bill
My final bill.
651.
This is a Boyd Graves Conference recommendation. This legislation specifies what actions qualify for statutory recoupment to include all defenses under contract. You'll see that the legislation specifies which defenses are available under law and equity.
Okay. Boyd Graves Conference, recoupment. Anybody know what recoupment means? Is it somebody here from the Boyd Graves Conference?
Mr. Chairman, members of the committee, my name is Samantha Sadovy from Reed Smith on behalf of the Virginia Bar Association. Recoupment is the right of a defendant to diminish the claim of a plaintiff because that plaintiff failed to comply with a provision of the contract or violated some other duty by law. This is a recommendation of the Boyd Graves Conference. The bill basically takes, in Virginia, we have both statutory and common law recoupment. This combines the two and puts it into statute so that there's consistency and clarity between the two.
Okay,
Is there a
Mr.
lack of clarity between the common law
Mr.
recoupment
Chair.
and the statute currently?
The statute hasn't been updated in over 40 years, so this takes what is in common law and puts it into statute so that it is consistent between the two, yes.
Senator Peterson?
I got an email from David Gogol. Is this his bill? He's in favor of this? Is this his version? Yes?
Yes.
Okay, that's what I needed. All right, thanks.
All right, is there
Mr.
any
Chairman.
further discussion?
Mr. Chairman, I had a
Yeah, Senator Serval.
My only concern about the text, and I raised this with David this morning, but again, I don't think he's replied to me. It's not clear to me why it says including instead of including but not limited to in terms of the various defenses that can be raised in response to a contract.
Is there a
It just-
motion?
It seems to me it ought to say including but not limited to.
Mr. Chairman, there is a provision in Title I of the code that says including means including but not limited.
Perfect.
All right, yeah, I remember in the Code Commission, we did that, I believe. Okay, it's been any further discussion?
There's an amendment to the bill as well.
Mr. Chairman, I received 2 amendments from the Boyd Graves Conference on line 12. After arising, strike under the contract and insert out of the transaction. And the same amendment would be made on line 20 after arising, strike under the contract and insert out of the transaction.
Strike under the contract and put in out of the transaction, okay? Is there a motion, second, that motion? All in favor of the motion, say aye. Aye, all opposed, no. Any further discussion? Is a motion been made to report the bill as amended? All in favor of the motion, vote aye. All opposed, vote no.
Ayes 14, no 0.
It's 14-0. Congratulations.
Thank you, Mr. Chairman.
Okay, thank you. All right, the next is Shelley Simons, Delegate Shelley Simons. Welcome to the committee, Delegate Simons.
Thank you, Mr. Chair. May I address the bill?
Yes, please do.
There's a substitute for this bill, which has passed unanimously from the House. HB 880 intends to make it easier for a petitioner to dissolve a protective order and to do so in a timely manner. Victims can, in particular, get preliminary protective orders quickly, and they should be able to dissolve them quickly if they determined the PO is not in the interest of their safety. This bill is supported.
Mr. Chair, was there a substitute, or were you talking about the House
I
substitute?
think the House substitute, right?
There's a substitute for the bill.
There's no Senate substitute, is
No,
there?
Mr. Chairman, you have the House substitute in front of
We
you.
have the House substitute. Yeah, that's your bill.
So the Virginia Poverty Law Center supports the bill, and they can answer if you have any detailed questions for me today.
Yeah, Senator Obenchain?
So, you know, we've had robust discussions over the past couple of years. I know that Senator Howell had carried legislation that was intended to protect victims of domestic violence from intimidation that causes them to seek dismissal or refuse to testify against the perpetrator of that domestic violence. Is this not creating the same situation in which the person who got the protective order
may be intimidated and seek prompt dismissal of it?
Mr. Chair, we did hear that concern, and that's why the substitute allows for dissolution with or without a hearing. That way, the judge can decide if they need to slow down the process, if the judge wants a face-to-face hearing with the petitioner. This bill would allow for that. This allows for judges to check if the victim is being pressured in an ex parte hearing.
Mr. Chairman.
Senator Obenshain.
And, one of the things I worked on when I first got here 16 years ago was trying to make sure that there is an adequate cooling off period. We have had a huge problem with people serially violating protective orders, and in my district, we had a just horrific double murder of 2 children who were kidnapped by somebody subject to a protective order, taken to a remote area and murdered. And that guy had violated protective orders a half dozen times. And we even had put in, have mandatory jail time for serial violators. And I just worry whether we're backtracking on the policy that we've established.
Mr. Chair, may I have my representative from the Virginia Poverty Law Center address that?
Go ahead.
Mr. Chair, Senator Obenshain, the thing is, these issues are nuanced, right? For people who end up getting preliminary protective orders or full protective orders, they may realize after the fact that this is not the best option for their safety. It may end up escalating violence or escalating conflict. And so the concept is, with the substitute that passed unanimously, that the judge, as Delegate Simon said, can issue the dissolution, which they're going to issue at some point, right? It is the petitioner's protective order to pursue, amend, et cetera. So the dissolution will be addressed, but if the judge feels that the petitioner is being intimidated or knows these parties, the judge can hold a hearing ex parte and talk to the petitioner and try to gather that information.
So, Mr. Chairman.
Yes, Senator Obenshain.
I don't think I've got a problem with the ex parte part, because the defendant's always going to have, always going to want it to be dissolved.
Exactly.
So why should they do it without a hearing? What about just striking leaving with a hearing and striking or without?
The reason I would want to keep with or without a hearing is to give judges discretion. For example, let's say I got a preliminary protective order today against my husband. It hasn't been served on him yet. We are in the middle of trying, I decide I want to give him another chance. Let's try to reconcile. The PPO hasn't even been served on him yet. Why not allow me to go back to court today or tomorrow to say, I actually want to dissolve this preliminary protective order. It's not in the best interest.
So, Mr. Chairman.
Senator Obenshain.
All right, so you've got a couple of different scenarios. One would be the maliciously initiated protective order. Okay, I'd want a hearing. I'd want them to have to explain to a judge, if you don't need a protective order, why'd you ask for it? Number two is a situation in which there's intimidation, threat of violence against the recipient of the protective order. And I would think somebody would want to at least explore the possibility that there's something going on. And dockets are extremely busy. Right. And I'm sure that with this statutory language, there'd be a great temptation to say, well, they don't want a protective order anyway, I'm just going to dissolve it. I'd feel a lot better if you just took out the or without. But
I think the problem, Mr. Chair and Senator Obenshain, I think the issue with taking out without is that some jurisdictions already issue these dissolutions without a hearing. And the point of bringing the bill was to encourage court efficiency. If a petitioner should be able to get a preliminary protective order pretty readily, she should be able to dissolve it pretty readily. Sure. So that was the thinking behind it. And one of the examples is a couple have a child in common. They got a protective order, child is ill, and petitioner wants respondent father to be able to go and visit with the child in the hospital, et cetera, and cannot contact the respondent and wanted to be able to dissolve it quickly. In some jurisdictions, it's taking several weeks even to set the hearing.
Okay. Any other questions?
Mr.
Senator
Chairman.
Morsi.
A couple of questions, Mr. Chair. The preliminary protective order lasts for how long?
Up to 15 days. The idea being that on the 15th day, by the 15th day, the full protective order hearing would be scheduled.
Okay. This motion to dissolve the preliminary protective order, does it set forth the reasons why the petitioner is moving to dissolve it? And does the judge have that full petition and those reasons in front of him?
It could. I don't know that it has to, but it could.
In other words, Senator Obenshane, thank you, Mr. Chair. Senator Obenshane is concerned about the following scenario. I move to dissolve it. That gives him
Just because.
Just because. I move to dissolve it. I would feel, and I assumed until that last answer, that the petition set forth the reasons, like, for example, the child is in a hospital. Do you see the potential problem? Don't you agree that that petition should set forth, to dissolve it, should set forth all of the reasons?
I think that's fine. I have no problem with that. I don't think Delegate Simons would either.
Wouldn't you agree that most judges would want to know, wouldn't they?
Right.
And say, how come?
Right, especially if you're going to issue the dissolution without a hearing. You'd want to know what the motion's about.
I think that's implicit.
Mr. Chairman.
Senator.
I just want to raise one other
McDougal.
point that the committee probably is aware of. There's no ability to expunge these orders. So once a protective order is issued, even if it's dissolved, it stays on your record forever. So we could have situations where a person had a preliminary protective order, it was never served, it was then dissolved, and they didn't even know that it had existed, and now they go through some background check and it could show up.
All dissolutions would have to be served on the respondent.
Okay. Any further discussion?
Mr. Chairman.
Yeah, Senator Sherrill.
Thank you, Mr. Chairman. Speaking to the bill, my only concern when I read this bill was that of a scenario where, say, a very abusive person could leverage the protective order, the person obtaining the protective order to drop it. And if it was done in an ex parte fashion, then the judge wouldn't have a sense that was really going on. But if they were forced to have a face-to-face with the person who holds the order, that might prevent that situation from happening. But, these folks are the folks that deal with the victims all the time, and they're comfortable with this concept. If they feel like they're comfortable with that, then I'm comfortable with it. That's kind of where I came out on it. So that's why I didn't.
Any further discussion? Is there a motion?
Motion to report.
Motion to report. Is there a second? Senator Dietrich seconds it. All in favor of the motion, vote aye. All opposed, no.
Thank you.
Ayes 13, noes 2.
13-2. Thank you. And congratulations.
Mr. Chairman.
13-2. Senator McDougal?
I think Delegate Simons is back in. I believe all the parties went outside after the substitute and were able to come together, and I know there were at least 10 or 15 people here. So could we reconsider the vote by which we pass this by for the week and bring it back up now?
Bring back up, what again? I'm sorry.
HB 790.
790, the homestead. All in favor of the motion to reconsider the motion to pass it by for the week? All in favor to reconsider that motion, vote aye. All opposed, no. Okay. Bill is reconsidered.
And Mr. Chairman, if I understand correctly, maybe as the parties got together, they were able to coalesce around the original version, and then we would strike out the Code Commission language and the CPI index. So with that, I would move that we need to reconsider the motion by which we accepted the substitute, because I think it'll be easier for us to work off the original version to fix those
All
two.
right, so motion to reconsider the vote by which we pass the substitute. All in favor of the motion, say aye. Aye. All opposed, no. Okay, so where are we now? Okay, reconsideration. All in favor of the motion, reconsider. Okay, all right.
Ayes 14, no
That's
zero.
14, nothing, okay.
So, Mr. Chairman.
Still want to put it off for the week?
No, Mr. Chairman, I think all the parties went out and came to an agreement, and the agreement would be, Mr. Chairman, that we change the language that references Code Commission. I think the chairman had wanted that to go to the Supreme Court, if I'm looking at, no, just take that language out. Just take that language out and take the
It would just take out
CPI
34,
index.
3.2.
All right, let's go through it quite
83,
carefully.
87,
Which-
strike those.
Which lines do you want to take
So-
out? I'll
sorry.
make sure we know what we're doing.
Yes, sir, Mr. Chairman, members of the committee, so starting on line 80 of the
80?
of the House version of the bill, right, which would be what's before you, which talks about automatic adjustment of expenses. You'd strike all of line 80 through the end of line 87,
Okay.
which is what set up that CPI scheme.
Okay. And I do that, just that, okay, all in favor of that line amendment, say aye. Aye. All opposed, no. Motion carries. Then what? What else?
Mr. Chairman, I think with that, I think everybody was satisfied that we have the right balance between protecting the real property, but not creating too large of a wild card for all personal property, which meant people were comfortable with this idea that it could reset every 8 years, which is the length of time between Chapter 7 bankruptcies. So I think that.
You need to take the Code Commission out of it.
Mr.
too.
Chairman,
Commission is out.
We struck that whole section
Okay,
that
all right.
referenced the Code Commission.
It will be a substitute, but I move to report the substitute.
All right, this is what you want, right?
Yes, Mr. Chairman.
Everybody's happy. Okay. All
Make sure
in
you ask.
favor, the motion, it'll be a substitute. This substitute, which simply strikes out lines 80 through 87, correct? All right. All in favor of the substitute, vote aye. All opposed, no.
That's what they told me when I went out in the hallway. Because we took the.
Ayes 15, no zero.
Okay, white smoke.
Thank you, Mr. Chairman. Thank you, Mr.
Okay.
McDougal. Thank you, members of the committee.
Thank you very much.
Was that reported?
Huh? I'm sorry.
That was a motion to report with substitute? Thank you.
Yeah, the substitute has been reported.
Very good. Thank you.
Yeah.
Thank you all.
Vivian Watts has been here, and she's not on the list, but I'm going to call her next. Okay, very simple bill,
All
I
right,
think.
very simple bill. This is
744.
744. And while possibly it would be easier to follow if it were in a substitute form, I would drop the purpose of the bill is to give flexibility to the sentencing judge when a juvenile has been convicted of an adult crime. And the flexibility that currently does not exist, the judge can suspend, the judge can sentence as an adult, the judge can, if it's a nonviolent crime, sentence as a juvenile. What the judge cannot do is deal with a mandatory minimum sentence, and it must be imposed. And what this bill does is give the judge the same discretion when it comes to mandatory minimum sentences. It allows them to impose it or not, or any part thereof in the total sentencing picture. And then the language at the bottom of the bill just guides general district, guides adult court judges in full consideration of the juvenile's circumstances in imposing the adult sentence, the same kind of guidance that would have been used in if should it have been in a juvenile court.
Let me ask you, do you need that last part, lines 55 through 58, is that really necessary? I mean, judges, I think, know these things.
It was reflective, though, of how far we have come in the recognition of the considerations that a juvenile may be facing, and that was why it was put in. It's granted, there are a number of judges who do know it. This is just giving that guidance in sentencing for all sides to realize the judge's decisions.
You want that in there, is that right?
I think it adds to the context of our law.
Okay. Anybody want to speak in favor of the bill? Yeah, come on up. Step right up.
Thank you so much, Mr. Chairman. James Dole, representing Human Rights for Kids. Just want to thank Delegate Watts for bringing this bill. It's a really important piece of legislation. And to your question, Mr. Chairman, I just want to highlight that several studies have shown that when it comes to adverse childhood experiences and early childhood trauma, that there's a direct connection and link now between children's exposure to that and their involvement in delinquent or criminal behavior. Matter of fact, a DOJ study that came out in 2012 showed that about 90% of children in the juvenile justice system have experienced at least 2 adverse childhood experiences, and roughly 30% of boys and 45% of girls have experienced 5. Particularly with girls, there's something that we call now the child sex abuse to prison pipeline, where there's a direct link between girls who have been sexually abused and their later involvement in criminal behavior. And so in terms of the judge specifically considering those factors, it's a really important component of this bill. We think will give judges a greater sense of what's going on in a child's life, what led them astray, and as they determine whether or not to depart from a mandatory minimum sentence or whether that's appropriate. And so with that, Mr. Chairman, I'd go and close my testimony and just say it's a really important bill, protects the human rights of children in the justice system, and we would urge the committee's support. Thank you.
Okay, next, you support the bill.
Mr. Chair, Amy Willard, Legal Aid Justice Center, we do support the bill. I would just say we represent these kids in serious offender review hearings, and there are a lot of times the judge is ready to release them from their blended sentence and feel like they can't because of these mandatory minimums. So I think this will actually alleviate some judges' concerns as well.
Okay, thanks. Prosecutor?
Good morning, Mr. Chairman. Nathan Green, Commonwealth Attorney for the City of Williamsburg, speaking on behalf of the Virginia Association of Commonwealth Attorneys. We did discuss this bill at length, and the prosecutors do support this bill as well.
Okay, is there a motion? Is there a second? It's been moved and seconded that the bill be reported and referred to finance. All in favor of the motion, say aye. Vote aye. All opposed, vote no.
Thank you very much, Mr. Chairman, members of the committee.
Thank you. Thank you. Okay, thank you very much. Delegate Lopez is here to introduce his son.
Oh.
Make sure you introduce your son.
That's my chief of staff. I apologize.
Okay, your chief of staff. He tells you everything that you need to know. Okay.
Could he present
the bill?
Yeah, he could actually.
All right.
He's that good. So this HB 262 basically addresses a public safety issue in Virginia. The problem is we've had this chilling effect on community police relations because state and local police are being perceived a lot of the time in immigrant communities as possible deportation agents. A recent report found that in the first 8 months of 2017, in South Arlington and the New American Latino communities, you actually had a 75% drop in the number of domestic violence reports. You had an 85% drop in the number of sexual violence reports. Is that because those things are not happening? No, it's because what you have are people who are too scared to report when they are the victims or witnesses of crimes, because if they do, they're scared that they or a loved one might get caught up in the ICE detention process. So what we have here is, I think, some simple fixes. Also, I'm working with Senator Searle and counsel from your committee. We were able to make some suggested amendments as well. But what we're trying to do here is essentially say that when members of Virginia's large and growing immigrant communities who are victims and witnesses of crimes fear that immigration will take action will be taken against them or their families, they what happens is they don't report those crimes to local law enforcement. And what that means then is that by not doing that, you're essentially making all of us less safe. Community-based policing has been time-tested for decades and a successful model for crime prevention and reduction, and I think this is a vehicle for helping us get there. Establishes a uniform statewide policy against routinely asking victims and witnesses of crime for their immigration status, and I think it helps ensure that no community is safe for criminals because it encourages Virginia residents to work with the police in bringing criminals to justice. And Mr. Chairman, if you have if you're okay, I'd like to just give this to the council. some edits that amendments we wanted to make in terms of
Okay.
being as completely protective as possible, and also taking into account the current status of the code and where's the places.
Council, read these amendments.
Sure. Mr. Chairman, there are two amendments. The first amendment is on line 16, which would strike cooperating in front of witness. And then the second amendment's the end of the bill. It's adding a new subsection C, which subsection C would say, nothing in this section shall affect the current status and implementation of section 18.2-59, 18.2-308.0910, and 18.2-308.2:B, subsection B1. And basically, that last subsection deals with the offenses of extortion of money, and there are two firearm sections where immigration status is an element of the offense. So this would just allow law enforcement to be able to investigate and ask questions as it relates to those offenses.
Thank you.
Okay, is there a motion to adopt the line substitute?
Yeah, before we vote on that,
Yeah, Senator Peterson.
just so I'm semi-educated, what do those code sections refer to?
I'm sorry.
Those code sections refer to, the first one, the 18.259, is extortion of money.
Okay.
And there is a section in the extortion section which prevents extortion from people about their immigration status.
Okay, all right, so that's clearly, what about 308?
And the 308s are two firearms because an alien cannot purchase
all
a
right,
firearm.
got it.
Right.
All right, is there a motion to adopt the line substitutes? All in favor of the motion, say aye. Aye, all opposed, no. Motion carries. Is there any discussion about the bill? It's been moved and seconded that the bill as amended be reported. Doesn't have to go to finance. All in favor of the motion, vote aye. All opposed, no.
Ayes 9, no 6.
As 9-6, the bill as amended is reported.
Thank you, Mr. Chairman.
Yeah, thank you very much.
And my chief of staff thanks you as well.
Yeah, Chief of Staff, congratulations. Keep your dad straight, okay? Thanks for coming. All right, the next would be Delegate Lindsay. Delegate Lindsay has House Bill 34.
Mr. Chairman, members of the committee, here on HB 34, which is which permits that a person who has been convicted first offense of unreasonable refusal to give a breath or a blood sample to, after a 30-day period, be able to petition the court for a restricted driver's license. The court may, if good cause is shown, grant such a restricted license for such purposes as presently allowed for the DUI code. And it also provides that in such an instance that that person will have to have an ignition interlock and also complete the alcohol safety program. This bill, if passed, would put Virginia in keeping with at least 34 other states as it relates to affording an ignition interlock for the first-time refusal. Likewise, this is a bill, if I've not said it, that has been endorsed by Mothers Against Drunk Driving.
Mr.
Okay.
Chair.
Any discussion? Yeah, Senator McClellan.
Mr. Chair, I have an amendment that staff can report in a minute to make sure we are conforming this to federal law, because under federal law, we are not allowed to give restricted licenses to someone with a commercial license. And so I have an amendment that would mirror language that is in the DUI section of the code to make that clear.
Okay. Is that an amendment before us?
Yes, Mr. Chair. Mr. Chair, there are actually two amendments. The first one is on line 79 after 18.271.1. The amendment would read, no restricted license issued pursuant to this subsection shall permit any person to operate a commercial motor vehicle as defined in the Virginia Commercial Driver's License Act. And then the second amendment is after line 119, a new subsection, subsection F, which would read, notwithstanding any other provisions of this section or of Section 18.2, 271.1. Nothing in this section shall permit the court to suspend, reduce, limit, or otherwise modify any disqualification from operating a commercial motor vehicle imposed under the provisions of the Virginia Commercial Driver's License Act.
Okay, is there a motion to adopt the line amendment? Moved and seconded to adopt the line amendments. All in favor say aye. Aye, all opposed no. Motion carries. Okay, do you have somebody speak for the bill?
Ma'am?
Yeah.
To the contrary. Mr. Chairman, members of the committee, my name is Kurt Erickson. I'm president of the Virginia-based Washington Regional Alcohol Program. We strongly support ignition interlocks and worked with many of you in 2012 when Virginia became the 16th state to require them for all persons convicted of a DUI. I just wanted to raise just a concern. I apologize to the sponsor, who I've not had a chance to talk to in advance. One is our concern about incentivizing refusals. If this bill should incentivize the number of refusals that people will engage in when they're on the side of the road, Virginia has a very low refusal rate. I'd hate to see that go up. I'm not here to express a remedy. Certainly there are some that are out there, but I just wanted to flag that. I'd love to know what the other states have done. The sponsor is exactly right. 34 states have some way to get a restricted license when those that are convicted of a refusal, but I don't know what their process has been in dealing with any kind of incentivization. Thank
Mr.
you.
Chair.
Okay, Senator Morrissey.
Delegate Lindsay, right now, is it not, it's a mandatory 12-month suspension of the person's driver's license for a first-time refusal, is that correct?
That's correct.
And this bill, and further question, Mr. Chair.
Yeah, Senator Morrissey.
And as most of us or all of us know, if you're convicted of what arguably is a more serious offense, the DUI, you're allowed to get a restricted driver's license so long as you have the ignition interlocked, correct?
And participate and complete the ASAP program, yes.
Mr. Chairman, it appears that the, again, arguably less serious charge of refusal now allows an individual to get a restricted driver's permit after 30 days. It seems to be practical and logical, and for that reason, I move to report.
All right, it's been moved and seconded to report the bill as amended. Any discussion? Somebody else want to speak? Yeah.
Yes, sir. John Mahoney, Commonwealth Attorney, Caroline County. I'm here representing the Virginia Association of Commonwealth Attorneys. And this bill will essentially gut the implied consent law. There's no incentive for anybody to take a breath test at this point. Now I'll tell the court that over the last few weeks, I've discussed this bill with many defense attorneys, and defense attorneys are shocked and gleeful at this bill. It's dangerous to the community. As somebody who gets those phone calls at 3 o'clock in the morning to go out and look at the dead bodies, which I've done too many times in a small jurisdiction, we cannot support this bill.
Mr. Chair.
Yeah, Senator Morrissey.
Mr. Mahoney.
Yes, sir.
Would you also argue that giving somebody who's been convicted of DUI the opportunity to have a restricted license guts the DUI law?
No, I wouldn't, because the DUI sanctions are progressive. And after a conviction for a first DUI, at least in theory, that reduces the likelihood that they will get a second DUI. So it kind of gives them a free pass on the first one.
Yeah, Senator Morrissey.
Would you agree with me that refusal, as far as the hierarchy of charges, is less significant than the actual DUI offense?
Well, I think the legislature has said that.
Okay, all right, thank you very much.
Mr. Chair.
Yeah, Senator Peterson.
Let me ask the Commonwealth Attorney, it's been a while since I've done DUI cases, but if somebody refuses to take the breath test, you can still have them walk the line or touch their nose or give them a field test, correct?
You can ask them to, but they don't have to, and usually they don't. If they're not going to take the breath test, they're probably not going to do.
But you can still take them to the hospital and have blood drawn, can't you?
You can get a search warrant,
right,
to get the blood drawn, and when they get to the hospital, they can refuse to have the blood drawn. The hospitals won't take it if the patient, they're a patient at that point, says no.
I've always thought, maybe I've got this incorrect, I've always thought that could be taken, that was considered physical evidence. If they have a search warrant.
That's a search,
But a lot of the hospitals won't take it.
a search warrant gives the hospitals be commanded to do it. Doesn't it?
I agree with you, and I've met with the hospital to discuss that, but
Mr. Chair.
they treat them as a patient. Now, it opens a door then to charging obstruction of justice.
Mr. Chair.
Yeah, Senator Morrissey.
Just for the benefit, if somebody is on the road and they're allegedly driving while intoxicated, the police officer is going to ask them, pursuant to the Virginia Implied Consent Law, to give a sample of their breath. They can say no, but then they're brought down to the magistrate, and it's only when they're brought down to before the magistrate, and the magistrate explains to them that as a result of being allowed to drive, you have deemed to have consented. Only then do they refuse. Is there a completed offense of refusal after being advised by the magistrate?
You know, if I might add, these days, people who refuse, generally speaking, and this comes from the defense attorneys who acknowledge that their BAC would have been very high, and they refused because they knew they could avoid mandatory jail time.
I'm sorry.
Yeah,
But
I'm
if
sure
they were
that's right.
if they were convicted of DUI, let's say that they were actually convicted of DUI, they would be able to still get a restricted driver's license, right?
Yes.
Fine. And they would also have to go through a VASAP program, correct?
That's correct.
Under Delegate Lindsay's bill, they still would have to go through am I correct, Delegate Lindsay, a VASAP program?
Yes.
And they can still get a restricted license. I'm having a difficult time seeing the distinguishing between a more serious substantive DUI offense and a refusal.
Mr. Chairman.
Senator Norman.
Enough of the debate. I move to report the bill.
Mr. Chairman.
Second.
Yes, Senator Stewart.
If I may, and I may second it, but I wanted to speak to this, and I don't have any questions for John. I want to speak to the bill.
Okay.
Because Senator Serval's not here, so somebody's got to be Senator Serval. So what the refusal procedure is designed to do is to force people to plead guilty. And even though I'm very much a law and order person, it drives me insane that you have every other right against self-incrimination under our Constitution, but yet if you don't comply with this procedure, then there's a civil offense which can take your license away for an entire year to force you to plead guilty to a criminal offense. My question, and by the way, if you get a search warrant, they will take blood. But my question to Delegate Lindsay is, why are you going about it this way? Why don't you just repeal the refusal section and take that away and give people their constitutional rights back?
Because Mothers Against Drunk Driving like this version.
They spoke against your bill, Delegate.
I can show you the letter that was sent to the Courts Commission on January 28th.
Mr. Chairman.
All right, yes, Senator Stewart.
The gentleman just got up and spoke against your bill, unless I misheard him. He said he didn't like it.
He's not with Mothers
He's not
Against Drunk
Mothers
Driving.
Against
He's a Commonwealth
All right, well, I won't
attorney.
make that amendment. I was going to offer a friendly amendment to just repeal the whole section.
Different bill.
I'd rather get what I think I can get through.
Yes. I second it, Delegate Senator
It's
Stewart.
been moved and seconded that the bill be reported with amendments. All right, Senator Peterson.
Amendment that he just suggested to repeal the whole code section?
Oh, all right. The line amendments that we've already adopted. That's next year. All right, all in favor of the motion to report the bill with amendments, vote aye. All opposed, vote no.
Ayes 13.
Okay, thank you. Delegate, okay, Delegate Collins is next in the block. Senate 60.
Only in name only, I think, Senator. I'm sorry. Good morning, Mr. Chairman, Senators. House Bill 60 solves a minor problem in our codes when it deals with substitute judges in juvenile and domestic relations court and general district court. This bill was introduced last year and was sent to the Committee on General District Courts, where it was then sent back out and said that this was a law that they thought should be done. What occurs is, several practitioners would know, a judge goes on vacation or sick and they call a substitute judge. That substitute judge is not an actual judge, but a practicing lawyer who's been appointed by the circuit court to sit as a substitute judge. Well, that appointment only lasts for 24 hours. So if they have a long docket, for example, they might have an 8-hour custody hearing in juvenile court, we're expected them to render a verdict before midnight that night. And they said that at midnight, that appointment ends, so therefore the order that they enter after midnight may not be valid. So this gives them 2 weeks to enter orders after their selection has been completed. And so hopefully, we haven't ran into this yet, but this was an opinion brought by the Supreme Court.
Isn't it, couldn't a judge enter an order nunc pro tunc as if it was done before?
No, sir. Mr. Chairman, I think the issue is that at midnight, at 12:01, that substitute judge is just a Joe Schmo lawyer like myself. So it's
Well, we're going to let the Joe Schmo remain a judge for 14 days.
Yes,
right?
sir.
Is there,
Mr. Chairman, one question.
Any discussion? Yes. Judge,
What is the deadline for
Senator Morrissey.
appealing? Thank you, Mr. Chair. What is the deadline for appealing that substitute judge's ruling or order?
Mr. Chairman, I would answer the senator by saying it's 10 days from the date the order is signed. Not 10 days from the, so even if this 14-day extension, if it takes the judge 14 days to render a decision on a custody case, on the day that order is entered is the day that the clock starts ticking for appeal purposes.
Follow-up question.
Yes, Senator Morrissey.
What is the total amount of time that a judge has in General District Court or J&D Court to revisit his ruling? Let's say he makes it on the day in question when it comes up in his docket, and there's a motion to reconsider. What is the total amount of time that judge has?
Mr. Chairman, is it 21 days? I'm going to phone a friend. 21 days. I'm getting nods from other people. Yes. Yes. Final answer. 60 days? 60 days.
All right. So
what
second
happens
final
then?
answer.
I guess the question is what happens then? Yeah, okay.
Right.
Yes, sir.
So given that, wouldn't it make even more sense? I like your bill. I do. More sense to extend it from 14 days to 60 days.
I would deem that a friendly amendment. I would look over to OES, who are shrugging their shoulders and leaving me.
Mr. Chair, hold on a second. I mean, you're giving him 14 days to enter a final order. Doesn't your 60 days begin to run from the entry of the order?
Right, correct.
So if we extend it 60 days, we basically be extending the substitute judge 120 days.
You have a good point, Senator.
Shouldn't the order, I don't want to rewrite your bill, but put something in that says, despite the fact that 24 hours is gone, he's no longer sitting as a judge, he does have the right whenever he enters the order, he has the right to enter the order and deal with reconsideration issues as well that are timely filed.
That makes sense, Mr. Chairman.
That makes more sense, doesn't it?
Yes, sir.
We're not going to do that right now, I guess. All right, is there any more discussion on this bill? Maybe go look, see if we can't maybe next year fix the rest of it.
Yes, sir.
All right, all in favor, is there a motion to?
Move to report.
The motion been made to report the bill. All in favor of the motion, vote aye. All opposed, no.
It's 15-0.
It's 15-0, the bill passes. Thank you.
Thank you, Mr. Chairman. Thank you, Senators.
Okay, Delegate Sullivan.
Thank you, Mr. Chairman, members of the committee. This is HB 834. I love carrying bills recommended by Boyd Graves, a bunch of lawyers much smarter than I. This bill simply brings the publication statute into the 21st century. What it allows a court to do is permit, if you're in a situation where you're serving by order of publication, it allows a court to allow, if the circumstances merit it, publication by electronic means rather than in a newspaper. The statute currently allows a court to not, to essentially overlook publication or skip publication if it finds that's proper. But sometimes there are situations where the known defendant's out of the state already or maybe even out of the country. Obviously, publication in that case isn't going to help any, but you might know the email address, or you might have know this person's social media, and you might be able to give notice that way. This would simply allow the court to say, assuming the circumstances warrant it, that you can give notice of a filed lawsuit by electronic means, either in addition to or in lieu of publishing in a newspaper.
Senator Obenshain.
I don't disagree, but, this, the statute gives objective rules right now for orders of publication. So you know that you've complied or not complied under the existing law. I mean, are you concerned at all that this may inject a subjective element that could make an order of publication subject to attack after the fact?
Mr. Chairman, Senator Obenshain, if you look at line 25 of existing law, the court's already allowed vaguely now, in any case where deemed proper, which could mean just about anything, so could apply in all sorts of circumstances, to dispense with such publication in a newspaper. So a court can already do that. What the statute doesn't do is specifically allow the court to do something else in addition to simply dispensing with publication. And it uses the same language. It puts it at the discretion of the court, and they'll have to find some reason to do so. Presumably that's going to be a plaintiff saying, I know where defendant X's, I know his email address, or I know where he lives in some other country, I can reach him electronically.
Okay, any further, no, you have somebody here who would like to speak?
I hope she's going to say something nice.
I am. Mr. Chairman, members of the committee, Samantha Sedevy from Reed Smith on behalf of the Virginia Bar Association. We would like to thank Delegate Sullivan for bringing this bill. Again, it's a recommendation of the Boyd's Graves Conference.
Okay, is there any further discussion? Is there any motion? Is there a motion?
I move to report.
Second.
It's been moved and seconded that the bill be reported. Any further discussion? All in favor of the motion, vote aye. All opposed, vote no.
Thank you, Mr. Chairman, members of the committee. Excuse me. Thank you, Mr. Chairman, members of the committee. Appreciate it.
Okay, the next is Delegate Bourne. Okay.
Thank you, Mr. Chairman, members of the committee. This morning we have House Bill 870, which simply seeks to eliminate an arbitrary distinction between sexual abuse claims that happen when a person's a minor and when they're adult. Right now, when a minor, you have 20 years from the time that claim would accrue. However, if you're 18, you have 2 years. And so, as we know, unlike other soft tissue ortho torts, sexual abuse, sexual crimes are different in nature. And so this would simply just make the statute of limitations 20 years across the board.
Okay.
Mr. Chairman.
Senator Shervill.
Thank you, Mr. Chairman. I just have a technical question for council. Not maybe the patron might have an opinion on it as well, but I litigated one of these things all the way to the Supreme Court of Virginia once. I remember there was a constitutional amendment that was adopted about 15 or 20 years ago to allow for retroactive modification of statutes of limitation when it comes to sex crimes like this. And I think normally when we monkey around with statutes of limitation, we put in some language about retroactivity. Do we need to put something in here about that, or is it the intent this be prospective only, or I just want to make sure.
Well, if it's, Mr. Chair.
Senator Peterson.
If it's prospective only, it's not going to be relevant for 20 years. So I've got my own opinion on this, but I'll shut up till the questions ain't.
Mr. Chairman, Senator Shervill, I believe the bill says that it's prospective. It says for any cause of action occurring on or after July 1, 2020.
It does. Right. Then there's no issue.
Prospective. Okay.
Question.
Senator Morrissey.
Of course, we're just speaking about civil matters, first of all, because there is no statute of limitation in criminal matters. Make sure I understand this bill. It would allow in a civil proceeding an individual, a plaintiff, who wants to bring a tort action against the defendant and was an adult and was sexually assaulted to be able to bring that case instead of within 2 years, which is now the limit, an additional 18 years up to 20 years.
Mr. Chairman, I would say to Senator Morrissey that's correct, because you could have a situation where I am 17 years old, 364 days old, and I turn 18 tomorrow, and I would have 20 years from that time because the claim would have been, I would have been an adult. However, if the offense happened the next day when I was 18, I would have 2 years. And there's really so yes.
Follow-up question.
Yeah, Senator Morrissey.
I'm thinking about the normal case where an individual, the victim is 30 years old. That person has 2 years until they're 32 to bring a cause of action. They now can wait 20 more years till they're 50 when time and memories have faded, evidence has been lost, to bring an action against the defendant. Is that right?
That's what this bill, Mr. Chairman, I would say to Senator Morrissey, that's exactly what the bill seeks to do. And I think we've seen lots of evidence and research that suggests that victims of sexual assault, sexual abuse, these things are different. They're very traumatic, and they manifest themselves very differently, and it may take longer for the person to be comfortable doing something like this. And so this really is, it's a policy question. And so I would think that we would want to provide victims and people who've experienced this type of stuff as many or as much opportunity as we can to get at least some level of redress.
Mr. Chair,
Senator Peterson.
first of all, the bill for underage was changed in 2010.
Right.
And it passed on a 38-2 vote. And I think Obenchain he and I were the only ones stupid enough to vote against it. So I've never liked this concept, but I really don't like this new concept. So I'm going to be consistent in not liking it. But it's one thing where it's a juvenile, and even someone who's 17 and 364 days is still technically a juvenile. And I understand 100% the discrepancy. The issue is where you have adults. And if somebody waits 20 years, and we don't need to pretend, there's been allegations made within people that work within this building. And 20 years later, these allegations now become salient. And can they be acted upon? Is it possible to still find witnesses? If you had a witness that would have helped a defendant establish their side of the story, is it still possible to find that person? Pretty hard to remember incidents that happened 20 years ago. Now, actually, for certain people, it's going to be very salient, and they may be able to testify in a very credible, compelling way. For other people, especially if you're on the receiving end of the allegation, it may be pretty hard to kind of recreate the events from that evening or that day. So I've never been a fan of the concept. I don't know why we had to jump to 20 years. I remember the original bill was originally 8 years and then became 20 years. So I just can't support this for the reasons articulated by my colleague.
Okay. Any other questions?
Mr. Chairman.
Yeah, Senator Obenchain. No, Senator Stewart.
Do I look like him?
No, you don't look like
Thank you,
Obenchain.
Mr. Chair. I share some of the same concerns of the gentleman of Richmond and Fairfax City when we're talking about people of age. I don't know how you prove it or defend it after 20 years. I really don't. And I'm wondering if the delegate would consider what I would move as a friendly amendment to strike 20 and put in 5 years. But I won't do it if you don't want to do that, delegate.
You don't want to do it. Okay.
Mr. Chairman, I would say to Senator Stewart, you never snatch victory from the jaws of defeat. So I would certainly consider that an improvement upon where we are today.
Okay. I'd move that amendment, Mr. Chairman, that we strike 20 and enter 5.
Been moved and seconded that 20 is stricken, 5 years is put in place of 20. All in favor of the motion say aye.
Aye.
All opposed, no. No. Chair's in doubt. All in favor, vote aye. All opposed to that amendment, vote no. Okay.
Ayes 13, noes 2.
Okay, the motion prevails. It's now 5 years rather than 20-year statute of limitations. Somebody want to speak in favor? Again, Bill?
Good morning, Mr. Chairman. Mark Dix on behalf of the Virginia Trial Lawyers Association. We thank Delegate Bourne for bringing this measure forward, and we support it. Thank you.
Okay. Is there any discussion? Is there a
Move
motion?
to report.
Motion to report the bill as amended. All in favor of the motion, vote aye. All opposed, vote no. Okay, strike the vote. Strike the vote. It was the wrong bill. Sorry. Now we got the right bill. Okay, all in favor of the motion to report the bill as amended, vote aye. All opposed, vote no.
Ayes 15, no zero.
Ayes 15, no zero. The bill passes.
Thank you, Mr. Chairman. I
Congratulations.
appreciate the members' time.
Okay, now we have Krishik, Delegate Krishik.
Thank you, Mr. Chairman. Members of the committee, HB 1044. So currently, the law is that tracking an individual without consent and through intentionally deceptive means is a Class 3 misdemeanor, which is on par with intentional damage to property, for example, and you know that it's only punishable by up to a $500 fine. This bill would increase it to a Class 1 misdemeanor, making unauthorized tracking punishable at the same level as stalking and like a violation of protective order. I'm seeing this method of stalking being used a lot by intimate partners to track and control their victims, especially when they're trying to escape to a safer location. I work for a nonprofit that helps people to helps victims of abuse to find homes that are safe. And what's happening now is technology is very cheap. This is not James Bond anymore. This is like LoJack, and even Sprint sells a little disc that you can get for $250 a month, and you can put it in a car anywhere you want. You can put it in your suitcases if you want. If you're going to lose your suitcase, for example, that's how they advertise it. But many states are now, this is really about catching up with technology. Many states are punishing this offense at the highest level of misdemeanor, some at felonies as well. So I think that it would be really helpful for if we could have a little bit of a harsher penalty put in place to deter this kind of dangerous behavior. And that's really the bill in a nutshell.
So all you're doing is raising it from Class 3 to a Class 1 misdemeanor.
That's correct, Mr.
It's
Chairman.
already the law. Okay. Any questions? Is there a motion? Is it moved and seconded that the bill be reported? Senator Morrissey moves, Senator Dees seconds, the bill be reported. All in favor, vote aye. All opposed, vote no.
Ayes 14, noes 1.
14 to 1.
Thank you, Mr.
Bill
Chairman.
is
Thank you.
reported. Thank you. Okay, Delegate Rome.
All right, thank you, Mr. Chairman. To the members of the committee, HB 1024 would establish a cold case database that be maintained and run by the Virginia State Police. This is to basically this is for homicides, missing persons cases, and unidentified persons cases. The bill, we did amend it in committee on the House side, and I'd be happy to take any questions.
Okay. Any questions? Cold case. Anybody speak in favor of the bill? Anybody speak against the bill? It's been moved. I'm sorry, it's got to go to finance. It's been moved.
Delegate, the state police are in support of this.
Yeah, state police.
Mr. Chairman, Senator Morrissey, Keenan Hook for the State Police. We don't have a position on the bill. However, we recognize the potential benefits of it where we would welcome the database within the department. Okay.
Okey-doke. It's been moved and seconded that the bill be reported. All in favor of the motion, vote aye. I refer to finance. All in favor, say aye. No. All opposed, no.
Ayes 15, no 0.
Ayes 15, no 0. Congratulations. Bill's
Thank you, Mr.
reported.
Chair. Thanks to the members of the committee.
Yeah, we need to refer, let me see. Yeah, House Bill 664, Delegate Bell's bill regarding expungement of deceased bodies' fluids to we already did that, didn't we? Okay, which one? 664, yeah, okay. I thought we did. All right, House Bill 664, we need to re-refer to education and health. The motion's been made and seconded to do that. All in favor of the motion to re-refer 664 to education and health, vote aye. All opposed, no? I thought we did that, no. Oh, okay, all right.
Ayes 14, no 0.
14, no 0.
Got two others there.
And I think, which would, any other bills? 610. Now, 610 is being passed by for the day. House Bill 610, Amaris, has been pass by for the day. He's not here, okay? If there's no further business, the meeting is adjourned.